Yes, Mr. Curry. Life has become so much easier for me, I just go straight forward for my chair. Yes, Mr. Curry.
Can we take representation as read?
By all means.
As you know, there are basically two categories of issue. The first is concerned with the scope of Section 172, and the second with the exercise by the Court of Appeal of the discretion under Section 996 of the Companies Act. You will have seen from the parties' written cases that the respondent, Saxon Wood, takes issue with whether some of what we say in relation to issue 2 falls properly within the terms of the appeal. We were going to suggest that since my learned friend has, we would say very sensibly, taken the pragmatic approach of answering our arguments on that in his written case, that you hear our argument as to why it's within the appeal, or why, if we need it, we should be allowed to run the argument anyway and give your ruling on all of that rather than having some sort of interim argument on.
Unless anyone disagrees, we'll hear it though, Ben the essay, and we'll sort it out in the judgment.
Very grateful. We start then with issue 1.1, and given the limited amount of time, we're not going to be repeating points we have made in writing, and we're not going to go to many of the underlying documents which we have given you the page references for, and you either already have or can read those materials for yourselves. So what we wanted to do was to use the structure of our written case essentially to emphasize important points and to respond to some of what has been said in my learned friend's written case. So what we wanted to start with is to talk about the law as it was understood before the 2006 Act was passed. You will have seen from our written case that we have 3 categories of material that we draw on: case law, professional commentary, and various summaries of the pre-existing law that were contained in the reports of the law commissions and the Company Law Review Steering Group, which we shortened to CLR. But before turning to those materials, we just wanted to make the point that it was Saxon Wood's own case that Section 172 involved a purely subjective test, both at trial and in the Court of Appeal, until the Court of Appeal itself raised the suggestion that Section 172 embodies an objective element. And we say that not as a tease point, not just as a tease point, but because it is an eloquent illustration of the fact that the established understanding of the whole profession, until the Court of Appeal gave its judgment in this case, was that Section 172 involved a purely subjective test. I don't ask you to go to, I think we've given the references in our written case, but just to remind you, the Saxon Wood's trial skeleton, the relevant paragraphs are 259 to 263, which is page 465 in the bundle. And we would ask you just when you have a moment to look at that, because an intentional distinction is there drawn between the objective elements that come into the claim for negligence and the purely subjective test that is being...
Which were the paragraphs?
Paragraphs 259 to 263.
Thank you.
Page 465.
Yeah. Yes.
And in the Court of Appeal skeleton, it's paragraph 20, which is page 503. As I say, I'm not relying on that to discomfort my learned friend, and not relying on it to assert that he, because he said it must be right, but we do rely on that fact simply as evidence of what the profession understood. With that preliminary point, if we could then look at first of all, the first category of materials that we deal with, which is the case law, and the starting point for that is going to be Smith and Fawcett, which is at page page 5009 in the bundle. and there are just a couple of short passages. They get quoted quite often, so you will no doubt be familiar with them. The case, as I'm sure you will recall, was about the director's power to refuse registration of a transfer of shares from a deceased shareholder to his executors. And if we look at page 5011, the opening lines of the Master of the Rolls judgment tell us that the principles to be applied in cases where the articles of a company confer discretion on directors with regard to the acceptance of transfers are, for the present purposes, free from doubt. They must exercise their discretion bona fide in what they consider, not what a court may consider is in the interests of the company and not for any collateral purpose.
This is an expression of what the collegiate obligation of the board is it not? It's how all the directors must act.
Yes.
And if an individual director took a different view about what was in the best interest of the company from the majority of the board, he wouldn't be, as it were, set free to go and do what he wanted, would he?
Well, that is a fact-specific question. The legal question under Section 172 is what is the duty of an individual director, not what is the obligation of the board acting collectively.
Well, doesn't the singular include the plural?
Yes, a director and the directors. Yes.
I.e. the board.
Yes.
And the 172 is as much about what the board must or must not do, isn't it, as what an individual director must or must not do?
Well, the duty is on individual directors with respect.
Well, of course it is,
and
but
the
it's also...
aggregate of that is what the board does. Yes.
But insofar as 172 is, as it were, encapsulating the old law was seen as what the board must do as well as what individual directors must do.
The board doesn't do anything different from what the aggregation of the individual directors must do with respect. There's no separate duty on the board.
But it's the aggregation.
Yes.
That matters.
Yeah, absolutely. I don't think we're disagreeing.
But
The other-
you say there's no rationality backstop for the
No.
duty. It's whatever he or she genuinely thinks is in the best interest of the company, however bizarre it may be for them to form that view, they have fulfilled their duty if they do that.
Absolutely. And I mean, I'm taking it entirely out of turn, but a point that is made against us is that would allow a lunatic to run a company genuinely believing that they were doing what's in the company's interests, but entirely unreasonably, and it is said that that can't possibly be the case. And our answer to that is that the obligation to act with reasonable care and skill would catch that behaviour, and it is entirely possible that the objective element in the obligation to exercise powers for proper purposes would also catch it. There is no need to introduce an objective element into the test under Section 172, phrased as it is. And just going back to the case law leading up to the Act, page 5013...
If a limit was lawfulness, you'd say the same, would you?
Yes.
You look at those other sections.
Yeah, absolutely.
If it was
And page 5013, about a third of the way down, 12 lines down, there's a line beginning with the word control. And the sentence that we rely on is the question, therefore, simply is whether on the true construction of the particular articles, the directors are limited by anything except their bona fide view as to the interests of the company. And over the page, 514, halfway down that paragraph, towards the end of a line, there's a sentence beginning, accordingly, on the evidence I'm satisfied, as the learned judge was satisfied, that there is no ground shown here for saying that the director's refusal has been due to anything but a bona fide consideration of the interests of the company as the directors see them.
But wasn't that in the context of the Articles of Association, giving them in this regard an absolute and uncontrolled discretion?
Yeah.
But there's no... Are you saying that everything they do is subject within their absolute and uncontrolled discretion as long as they really believe it?
What is being articulated there is the test to be applied in seeking to challenge a decision by the directors. And the test that is being applied is, do they, in fact, consider that what they are doing is in the best interests of the company. That's the legal test that's being applied to, yes, that particular discretion. If there were other restraints on the discretion, that would be a separate reason for challenging its exercise if those constraints have been violated. But he's saying there aren't any other constraints. So the only question is, was it a decision taken genuinely in the interests of the company?
It is for note that this case is about the directors acting together,
Yes, absolutely.
whereas our case is about a director who decides, if you like, to subvert the decision-making organ of the company, which is the directors acting together, and to impose his own subjective view, where he knows that the proper view to be taken about how the company's business should be managed should be a view taken by the directors acting together.
Well, that...
So how does Section 172 apply in that sort of situation?
Well, it applies exactly according to its terms, that the director is himself required to, in the exercise of his powers, to do what he considers is in the best interest, well, to act in the manner best calculated to promote the interests of the company, and that is what the judge decided my client was doing.
Can I just explore that by a simple example? Suppose a company has 3 directors, and it's a majority rule on the board, company like most are, and 2 of them decide that route X is the way forward for the company, and the third one thinks that route Y is the way forward for the company. Does that mean that the third one, let's suppose he thinks that perfectly genuinely and honestly, that it actually is route Y and his colleagues are mistaken. Does it authorize, does Section 172 then authorize him to apply, to go, as it were, behind their backs to achieve route Y, and if necessary to mislead them by pretending he's actually trying to achieve route X?
It's not a question of authorization.
Why not?
Because the question under Section 172 is there a breach of a duty? And if the duty is characterized as a duty imposed on a director to do what he considers is in the best interests of the company, then it is not a breach of that duty. It might, I'm not going to speculate beyond simply saying, it might involve a breach of something else. But we are only concerned with Section 172. And 172 obviously also has to be read in conjunction with 173, which is a positive duty on directors to form an independent judgment. So the answer to your Lordship's question is, with respect, that the question is unfairly posed because we are not talking about questions of the Companies Act authorising something to be done. The question under Section 172 is, if something is done, is it a breach of that duty? And the way it was understood, as we say in Smith and Fawcett, is that that was a purely subjective question. That was followed in...
Sorry, just on the way that you're putting it, I wonder how helpful it is to sort of draw a distinction between is it a breach of duty, and you should think of it in those terms, as opposed to authorisation. Because if one looks at Section 172, it is, in a sense, it's the other side of the coin. It is saying you'll be fine if you act in a way that you consider in good faith would be most likely, and so on. I mean, so that can, why can't that be regarded as a form of authorisation? It's saying, if you act in this way, there will not be a breach of duty.
No,
you're authorised to act.
With respect, the authorisation of directors to do things comes from the company's constitution, not from the Companies Act. The directors have vested in them powers of management under the company's Articles of Association. What the Companies Act does is to constrain the way in which those delegated powers of management are exercised. So you're not looking in the Companies Act for an authorisation. You're looking for control mechanisms that limit the way in which the powers of management that are conferred under the Articles are exercised.
So you say the objective elements are likely to come into other duties, for example, Section 171, or indeed the duty of care and skill and care.
Absolutely.
But this particular section, which is how this case has been pleaded, is entirely subjective.
Exactly. That's the point. And that's how it was understood. We've spent a little longer getting to this point, but...
Sorry, I'm so sorry to interrupt again, but you say authorization is under the Articles of Association, but the Articles of Association in company law have never stood alone. They've always been supplemented by a series of duties which essentially have come from the common law. So I just wonder whether a rigid idea of authorization being solely based on the Articles of Association, and there's no element of authorization in the general law that says how you are to act, is correct.
Well, with respect, we would urge you that it is correct, because the way in which these two elements work is that the constitution of the company delegates the power, and the legal constraints on the way that the power is exercised are derived pre-2006 Act from the general law, post-2006 Act from the Act. So the Act isn't conferring powers of management. It doesn't say that anywhere. What it does is it lays down the legal constraints on the exercise of the powers that the directors have under the company's constitution.
And that's Section 171.
Exactly. That is a provision that expressly requires directors to act in accordance with the company's constitution. But that's not the debate we're having.
But Section 1721, which is the debate we're having, isn't really expressed in terms of constraint, is it? It's expressed in terms of must act.
Yes, that is the legal...
In other words, it imposes a duty.
Yes, which is a constraint on the way in which a power, which is conferred somewhere else, is exercised. That's what the duty is.
I'm sorry, the original question I asked you was about authorization, but can I just put the same question in terms of duty? If an individual director, bona fide, he takes a different view about the way forward from the majority of the board, who have embarked upon a different policy than the one he thinks is best, does Section 1721 impose on that individual a duty to go so far as to undermine the implementation of the majority's decision behind their backs?
Well, with respect, again, that question is unfair and wrong. We are not saying that Section 172 imposes a duty to do anything that my client did in this case. The question is, given what my client did, was he in breach of the duty under Section 172? And if he did what he did, genuinely believing that it was in the best interest of the company, then he is not in breach of the obligation to do what he considers in the best interests of the company, because that's the test under 172.
But why, pursuing my Lord's question, given that he thought the best thing for the company was to go behind the board's back, why doesn't that impose a duty on him under Section 1721 to go behind the board's back? Precisely because Section 1721 imposes a duty to act in what you believe, on your argument, subjectively is in the best interest of the company, and ex hypothesi, your client believed it was in the best interest of the company to go behind the board's back. So why wasn't there a duty, on your argument, for him to do that?
The only question on the analysis that is being advanced by the petitioner is a breach of Section 172. If my client considers that he has complied with the obligation under Section 172, we're not saying he is duty-bound to subvert something. The question is, having done what he did, is he in breach of that duty?
But forgive me, I'm just asking the question, and I believe my Lord is, to test your interpretation of Section 172, and I'm asking why isn't the logic of your argument that Section 172 does impose a duty to subvert the decision-making processes of the board?
My Lord, well, that in itself is a loaded question, because it assumes that there is subverting a decision of the board, whereas...
Well, that's what the judge found, wasn't it, effectively?
Well, the facts of this case is that a shareholders' agreement was made.
But the board must have said, well, we're going to cause the company to follow the shareholders' agreement.
That isn't, so far as I'm aware, a finding of fact in the trial judgment. The question that the Court of Appeal relied on was that my client caused the company not to comply with a contractual obligation under the shareholders' agreement.
But as I understand it, his fellow directors effectively said to him, you go off and achieve the out by the end of 2019. So the board was saying to him, we want you to achieve this company policy. The policy is ultimately a matter for us, whatever the shareholders may say, but actually we agree with the shareholders.
Yeah.
I thought that the factual circumstances, as have been established, involved findings that your client was fearful that the board would not back his business judgment on this, and therefore he deliberately kept matters from the board so that they could not exercise their business judgment, and it was left in his hands and just a matter of his business judgment as to what should be done.
Well, with respect, I didn't want to get into the facts because they are relevant on issue 2, but the short answer to your Lordship's question is that what was found in the trial judgment was not in our submission that my client withheld things from the board. Paragraph 102 of the trial judgment shows that the majority of investors were in fact content to leave matters to my client. It was Mr. Loy and Mr. Flamini with whom my client had fallen out, and it was from them that certain information was withheld. And it was Mr. Loy's complaint, paragraph 104 of the judgment, it was Mr. Loy's complaint about that exclusion that formed the basis of the complaint. So the situation is actually much more nuanced than the Court of Appeal appears to have thought. The Court of Appeal appears to have proceeded on the basis that the board collectively was misled. If you go through the trial judgment, it is a much more nuanced decision than that. And what is said is that 2 of the individuals,
Who are sorry, just remind me.
Loy and Flamini,
Yes.
are
Are they directors?
Yes.
Right.
And they are the ones with whom my client had spectacularly fallen out and were accusing him of various things that the trial judge found my client was not guilty of. But the finding of the trial judgment is that, and I said so I didn't want to get into this now, but since you've raised it, the finding of the trial judgment is not that collectively all directors were misled. The trial judgment says that the complaint, and it's paragraph 104 is the best illustration, where he explains that Mr. Loy doesn't really give any useful information because the substance of his complaint was his exclusion from the process.
But sorry, you just told us he's a director. I mean,
Yes.
so he is part of the decision-making organ for the company.
No, I don't.
And he's cut out of that by your client's actions.
Yes, I absolutely.
And if a director is accused of misleading the board, he can't say, well, I only misled 2 of them, because I actually told another 2 what I was doing. Surely the board means all of them.
Well, when you say can't, my lord, I'm simply addressing you as to what were the factual findings in the trial.
Yes, but the factual findings were that he did in fact he did in fact effectively mislead 2 members of the board.
Well, that in itself, my lord, again, we are getting into the factual territory.
Yes.
I didn't want to now, but what the judge says in a critical point of his judgment is that he appears to have given him the impression he was doing X, Y, and Z. Yeah. I agree he then does use the word misled elsewhere.
Yeah.
Right. But we got into the facts because you were taking me to task on the way that I characterised things in my question, where I was asking, following on from my Lord's question about the nature of Section 172, which is that it imposes a duty to act in a particular way if you have a view as to what's in the best interest of the company. And my question was, why was there not a duty on your client to act so as to subvert the decision-making by the board as the proper organ of the company to take these decisions? And you said, well, and then we got into Mr. Loy and Mr. Flamini.
No, fair enough.
And I'm now coming back at you. Having been through the detour through the facts, it seems to emphasise what I was putting to you, that there was a subversion of decision-making by the board, the proper organ of the company. You've demonstrated that there was by taking us to the facts. So let's go back to my question. Why, on your interpretation of Section 172, do you say, what do you say? Well, it seems that the logic of your argument is that your client was under a duty to do just that, subvert the decision-making organ of the company.
His duty was to do what he considered to be in the best interests of the company, and if that involved delaying the exit beyond the end of 2019, yes, that was a discharge of his duty.
So I'm now understanding you to be submitting that, yes, he was under a duty to subvert the decision-making organ of the company. That was his duty under Section 172, according to you. That seems logical. That seems to be the logic of your argument, and I think you're accepting that is the logic of your argument.
The logic in our submission, that one's got to keep a clear distinction between what he decided and the effect of what happened. His decision, in good faith, in the best interests of the company, was that the exit would only profitably produce a value for the company if it was deferred beyond the end of 2019. The question whether there isn't a finding of fact that he therefore decided to mislead anybody. There just isn't a finding of primary fact in that regard. So what we are left with is a finding of fact as to his state of mind in relation to deferring the exit and the acts that he then did in order to achieve that outcome. And that is why issue 1.2, it focuses on the question of whether the duty of good faith under section 172 applies to the state of mind or the actions of the director, because the findings of fact relate to his decision that deferring the exit is in the best interests of the company. There is no finding of fact that he decided to mislead anybody, and the way in which the decision on misleading is expressed is somewhat equivocal. So, my Lords, can I just get back slightly on track? The route I was endeavouring to steer was the pre-2006 Act case law. We've looked at Smith and Fawcett, and there are a number of other cases that we've cited in our written case: O'Neill de Falb and Runciman and Popeley and Planarive. All of those adopted in our submission a subjective test. The only quibble my friend has is in relation to O'Neill de Falb, where he says Lord Justice North appeared to recognise a partly objective test, because he says that the directors could not, in that case, in good faith, have thought that the transactions in the best interests of the company.
And sorry, the paragraph in your printed written case, whether
in our printed case, we are at the moment addressing you in relation to paragraph 17, so it's page 31.
Yes, thank you.
So O'Neill de Falb, Runciman, and Popeley and Planarive. The only quibble, as I say, is in relation to O'Neill de Falb, where a learned friend says that Lord Justice North's words contemplated a partly objective element, and in our submission they did not. What Lord Justice North in that case was saying was that in a situation where the directors had pocketed company money, they could not in good faith have considered that was in the best interests of the company, because the good faith element is the duty of loyalty, not to be in a position of conflict. And if they are interested in the outcome, they cannot, in good faith, have decided that it was in the best interests of the company, because that is a breach of the duty of loyalty. But it was not...
That would be a breach of 172.
Exactly. That was not the application of an objective test.
Can I just ask, I'm sorry to interrupt, but back on the leading case of Smith and Fawcett, I don't think you drew our attention, but I may have missed it, to the second sentence, which, as I understand it, is normally the sentence relied on. Are you, that's the sentence, they must exercise their discretion, bona fide, etc.
Perhaps I could ask my lord, sorry, just for the page.
Page
which was one of-
5011.
Thank you.
Do you say that that sentence it has now been encapsulated in section 172?
Yes.
Or
100%.
the only reason I ask that is that they must exercise their discretion bona fide looks as if it's talking about bona fide in relation to the exercise of the discretion rather than in terms of what they believe.
That is certainly the interpretation of that. But if you look at 5013,
Yes, they're the ones you took us to.
well, no, I thought I had. If I apologise, if I didn't.
No,
but
maybe
5013, it doesn't appear to be intending to say anything different.
Yeah.
But it uses the words the directors are limited by anything except their bona fide view as to the interests of the company.
Thank you.
Right, so if what he decides, he says he decided was in the best interest, if that's completely irrational, you may say, well, that may lead the court to conclude that he didn't actually bona fide do it, but if the court thinks he did really believe that, then that's a get out from
Exactly.
172.
Exactly, and that is precisely, my lady, that's precisely the point that's made in the leading case of Regent Crest, which you may have seen. I don't have time to go to it, but it's paragraph 120, which is page 5358, and the judge makes exactly that point. If a director claims to hold a thoroughly improbable view, the way the court deals with that is not to impose an objective test, but to say, I don't believe you actually thought that. And it's treated as a purely evidential question. My learned friend has a number of points in response to this line of authority, but the one thing that we would say by way of preamble is that my learned friend has not identified any case predating the 2006 Act which does in fact impose anything like an objective test. The other point he makes is entirely tangential, where he says in paragraph 32 of his case that although it would be a breach of a fiduciary duty motivated by self-interest, he says that's not the only basis on which a fiduciary duty can be broken, and he cites Howard Smith and Ampol, with which we agree that Howard Smith and Ampol is the sort of locus classicus for the proper purpose rule, which is section 171. So that doesn't assist on the contours of section 172. The other point I just wanted to respond to is in paragraphs 48 to 53 of my learned friend's case, where he says that the introduction of the objective Ivy test of honesty, in his language, does not offend the subjective nature of the section 172 duty. That's paragraph 52 of my learned friend's case, at page 73 of the bundle. And we would just make two short responses to that submission. The first is that it is an acknowledgement of the subjective nature of the section 172 duty. And secondly, insofar as the assertion is made that the introduction of the Ivy objective test of honesty would not offend against that, we would strenuously take issue with that, because it is perfectly obvious that the Ivy test does involve an objective test. My learned friend says, well, the first thing you do under Ivy is to identify what the director's state of mind is. But that's not the legal test for determining whether he's in breach of his duty. That's simply the evidential preamble to the application of the legal test, which is purely objective, is would that state of mind or that action be considered dishonest by ordinary decent people, using the language of Ivy. And that is an overtly objective test, which is exactly contrary to what was said in the authorities leading up to Regent Crest. We identify in the second category of material, apart from the case law that preceded the 2006 Act, the second category of material we rely on is professional commentary, which is in paragraph 19 of our case. Again, there's no need to go through it on our feet. We've given you the bundle references to Palmer, Hollington, Gore-Brown, and so on. Again, the only points we just want to emphasize again is that the professional commentary spoke with one voice before the 2006 Act was passed, and neither the Court of Appeal nor my learned friend have identified any commentary predating the 2006 Act which suggested that an objective test of honesty applied in relation to this particular duty. Third category of material that we rely upon to validate the orthodox view is the reports of the law commissions and the Company Law Review steering group. And as you will have seen from our written case, we rely on those reports for two purposes. First, because they contain summaries of the law as it was understood before the 2006 Act was passed. And secondly, they obviously then go on to explain what the 2006 Act itself was intended to provide. So they provide both the pre-legislative general law position, and they provide an aid to the interpretation of the Act in terms of what the Act is trying to achieve. Those two purposes are conceptually distinct, and we dealt with them separately in our case, but it's easier just to go through those reports insofar as we have time to do so in one go, rather than jumping backwards and forwards from what they said about the pre-existing law and what they said about what the Act was going to achieve. Simply in terms of the admissibility, relevance and weight to be attached to them, there is no dispute that these reports represent a legitimate source for both of the purposes on which we rely on them for. The one point my learned friend's case makes in paragraph 74 is that the reports are not binding statements with which we agree, and we have never suggested that they are, but the reports are, with respect, entitled to particular respect for four reasons. First, the reports of the law commissions, plural, are reports of both the law commissions of England, Wales, and of Scotland, and as it happens, they included over the years 3 members who have ended up in this court. Secondly, the composition of the Company Law Review Steering Group was equally distinguished, including Lady Arden and Richard Sykes, who, as we heard at Lord Richard's valedictory last week, is to be regarded as a source of company law in his own right. The third point is that the reports that we are looking at were specifically considering company directors' duties, among obviously many other things, but they were the specific focus of attention. And the fourth important point is that both bodies reported multiple times over many years, spanning the period from 1998 to 2001. There are 2 Law Commission reports and 4 CLR reports. And again, as I say, without going through the individual passages which we have identified, we would urge on you that 4 themes emerge clearly from these reports. The first is that the duty on company directors to act in what they believe to be the best interests of the company was regarded as an aspect of the distinguishing obligation of loyalty which was subject to a purely subjective test. Secondly, just to underline that point, a clear distinction was drawn between the test for good faith, which was subjective, and the test for honesty, which was recognized to be separate and involved an objective element. Thirdly, specific consideration was given to incorporating an objective element into what became Section 172, and a deliberate decision was taken not to do so. And fourthly, a similar clear distinction between the subjective test of the fiduciary duty of good faith and the twofold objective-subjective test for the duty of care was drawn. So, both in relation to the duty of care and in relation to a possible duty of honesty, the reports give specific consideration to the possibility of an objective element being introduced. It is of critical importance that a avowed decision was taken not to include that objective test of honesty. Law Com 1, we've given the references in the time that we have. I don't have time to go through them. CLR1, similarly, we've given you the references. The only additional point we would make in relation to the first CLR report is that in my learned friend's case, they say, well, you haven't referred to, I think it's Annex H, which contains some Australian legislation which is included as an example of a codification of directors' duties, incorporating an express duty of honesty. There's a point made, so this is Saxon Wood's written case, paragraph 76, referring to Annex H to CLR1, which is at page 1243. And our response to that point is simply, in a sense, amen. Yes, look at what Australia chose to do. The English reports specifically chose not to do that. Australia does expressly enact a duty of honesty, and a deliberate policy decision is taken in the English reports that that is not the road that the 2006 Act goes down. The one paragraph, so that's, we've done very briefly, Lawcom 1, CLR 1. Lawcom 2 contains the one passage that I would just want to put in front of you while I'm on my feet. So Lawcom 2, it starts at page 1253. And the passage I just wanted to emphasize is at page 1307.
Yeah.
If you look at paragraph 435, if you haven't already had an opportunity to do so, you'll see that the Law Commissions said that they had asked consultees whether they considered that the draft statement in Appendix A set out the principal duties under the general law. The consensus on consultation was that it did. Furthermore, over 80% of directors in the empirical survey also thought that the statement was about right in terms of content. This does not mean that Appendix A could not be improved, and we would expect the outcome of the debates of the Company Law Review may affect the content of the statement. For example, it could contain a duty to act honestly on the basis that this would impose an objective standard of behaviour, which the requirement to act in good faith does not, and is a concept which can be given dynamic interpretation. So an express statement there is made that good faith, which is the element that featured in the general law duty to act in the way in which a director considers in good faith is in the best interests of the company, does not carry an objective test, whereas the introduction of a duty to act honestly would. And the footnote is significant, footnote 40, where express reference is made. I just mentioned this simply partly for the date of Royal Brunei Airlines, 1995, where the Privy Council had held that dishonest assistance in a breach of trust carried an objective test of honesty. That is relevant for a later part of the argument, which we'll come to. But what we emphasize...
Sorry, Mr. Crowe, I'm sorry to take you back, but I was just looking at the Australian annex. As I understood it, you were suggesting that at page 1243, the Australians had explicitly incorporated a duty to act honestly, did you say?
If I did, and if I'm wrong, I apologise. Was this actually a proposal rather than an actual bit of legislation?
Well, I can't see any reference to honesty on page 1243.
Okay. I apologise if I've got that reference wrong. Can I come back to that?
Yes.
Sorry.
Thank you.
Yes, I'll come back to it. I apologise.
It was 984.
984.
Sorry, 984. Sorry, yes. Sorry, I may have given the...
It's probably me that got it.
No,
The wrong reference. Thank you. I can see that.
I think actually my notes are confused. Yes, I gave the wrong reference. It's 984. Sorry.
Thank you very much.
Thank you. So, as I say, Lawcom 2, important because it expressly recognises that the duty of good faith does not consist of an objective test of honesty, and it contains an express invitation to the CLR to think about introducing such a duty. CLR2 then does float that possibility. That's, I don't have time to go to it, but it's page 1551, and you'll see the executive summary at page 1558, and a draft codification which expressly proposed an objective test of honesty under General Principle 1, which is page 1593, whereas the core duty of loyalty did not connote an objective test, which is pages 1597 to 1598. And what CLR2 then asked its consultees was, should we include this objectively tested duty of honesty? And the answer and the decision it reaches in CLR3 is no. And if we could turn that up, it is in the CLR3 starts at page 2022. And paragraph 3.13 on page 2058 explains that they had thought about it and expressly decided not to introduce an objective test of honesty. An explicit duty of honesty on directors would be relevant only where it could be argued that honesty required the directors to do something which is contrary to their duties, in particular their duty to act for the success of the company as a whole. It's very difficult to predict how such an indefinite duty of honesty would be interpreted. For example, if it was in the interests of the company in this sense to terminate a contract, would a duty of honesty prevent this? Such termination would be entirely proper in many cases. Opinion may differ about whether it would be honest. Uncertainty of this kind is undesirable and, in our view, unnecessary. We doubt whether an explicit duty of honesty would add significant protection over and above that provided by the general law, and it risks creating uncertainty. We do not, therefore, propose to include an explicit duty of honesty as part of the director's duties to the company. And they then deal separately with the paragraph 315, the core duty of loyalty, which by definition does not carry that objective test of honesty.
So are you saying then that there's nothing between, at the one side, a test which is purely subjective, however irrational you are, if you really, really believe that what you're doing is in the best interests of the company, that's fine, and the alternative to that is you're dishonest, there's no sort of objective element that you can bring to bear that's not a requirement of dishonesty?
Not within 172. There is in negligence. So a duty of care is a duty to exercise...
Yes, no, I'm talking about within 172.
Yeah,
It's
within
either,
172, the answer to
it's
your question.
either got to be you're dishonest, you have to be dishonest, or if you're not having a dishonesty test, then it has to be a purely subjective test with no rationality backstop.
That's our submission and our analysis, and I'm not aware that anybody has suggested there's some middle ground between the two. There are a number of points that we just wanted to respond to in relation to my learned friend's case, and this is responding to paragraph 81.1 of his case. Sorry, paragraph 81 of his case, and I just want to deal very quickly with the 3 points he makes there.
Page?
It's page 80.
Thank you.
The first point, Saxon would say in 81.1, they says that the company law review did not suggest that a director could act dishonestly towards a company. But that, with the greatest respect, is a non-point in relation to the issue which we are debating. The question is simply whether the general law, before the 2006 Act was passed, imposed on directors an objective test of honesty, and whether the intention of the 2006 Act was to impose an objective test of honesty. And for the reasons we've given, the answer to both questions is plainly no. And nothing identified by Saxon Wood or by the Court of Appeal suggests otherwise. Second point Saxon Wood makes, 81.2, is they say that CLR3, the passage we've just looked at, 313 of CLR3, was written on the assumption that the duty of honesty and the duty to act in the best interests of the company might come into conflict. Whereas Saxon would say in their case that the Court of Appeal has decided that the duty to act honestly forms part of the duty to act in the manner the director considers in good faith to be in the best interests of the company. But with the greatest respect, that doesn't advance my learned friend's argument at all. We are relying on CLR3 as an aid to the understanding of the pre-existing pre-2006 Act law and what the 2006 Act intended to achieve. It is perfectly clear that the pre-existing law and the draftsman of the 2006 Act considered that the duty under what becomes Section 172 is not subject to any objective test of honesty, and that is the short and, in our submission, unanswerable point. Indeed, the very fact that Saxon Wood puts their argument as they do, namely the possibility of a conflict between the duty of honesty and the duty to act in the best interests of the company, demonstrates that the two are entirely distinct. And the fact that the Court of Appeal in this case reached the opposite conclusion, apparently in ignorance of CLR3, is simply with respect to restate the issue in the appeal, not to answer it.
Can I just ask you what then one does about a dishonest fiduciary? Are you saying, well, that's a matter for what, the criminal law? I mean, what is the general law that we're talking about? Are you putting forward the proposition that there is no fiduciary duty to act honestly in an objective sense?
I'm not saying that, and I don't need to. The only argument at the moment is, what does 172 contain? We entirely accept that honesty has a role in fiduciary relationships. If a director, for example, if he can prove he acted honestly and reasonably, that's a defence to a claim in negligence. If, conversely, if a director is shown to have acted dishonestly in misappropriating company money, that is going to be a breach of his duty, not to put himself in a position of conflict.
Well, that's not a good... Him taking the money is a different thing. Let's focus on something less clear-cut. We're talking about his view as to what is in the best interest, because people convince themselves that what is in their best interests is actually also in the best interests of the company.
Yeah.
There may be findings about that sort of thing here. So let's not use examples of expropriating the company's property. That's pretty clear cut. But what can you answer the question in a different way?
I apologise if I appeared not to be. I was certainly trying to. As I understood it, the question was, if we are right and objective honesty doesn't form part of 172, where does it have a role in relation to directors' duties? And the answer is, for example, in relation to an objective test, it would be relevant in relation to
Reasonable skill and care.
Reasonable care and skill. It'll be relevant to misappropriating company property. It'll be relevant to any attempt to rely on section 1157 to say that the director acted honestly and reasonably and ought to be excused.
That's not perhaps a very good example, because and reasonably obviously imports objectivity.
Yes, exactly.
It doesn't tell you much about what honestly means in that context.
Well, it doesn't tell you much about what honestly means. What it does is to illustrate that the Companies Act uses the word honestly when it means it. And section 1157 expressly uses the word honestly. And in section 174, it uses the word reasonably. So when it intends to impose an objective element, it says so. And that is why it is so significant that section 172 doesn't.
Then you would say, presumably, well, of course we've got the whole general law on the tort of deceit.
Exactly.
That would come into play, but we're not sort of disputing that, as I understand it.
No, we're not there. Exactly so. The third and final point that my learned friend makes in paragraph 81 of his written case is he says that there is high authority for the proposition that a fiduciary can't be bound by his fiduciary duty to cause a breach of a binding legal obligation. And that found some resonance in the Court of Appeal in paragraph 119. And the answer to that is that we do submit that that is a false way of putting the point. The question, we are not saying that we're not saying that our case depends on demonstrating that my client was bound to cause a breach of a binding legal obligation. The question is whether he is in breach of a duty under section 172 in choosing to do that.
Can I just ask you while it's in my mind, 1721, on your analysis, do you need the words in good faith?
In our submission, that does, and it is a point taken against us in the Court of Appeal and by my learned friend, they say that our argument strips that of any value. And in our submission, what good faith connotes in this context is the duty of loyalty, which is, as my Lord Burrows put it in Recovery Partners in Rukadze, the sacrifice of self-interest. So the duty of loyalty, meaning if you are interested in the outcome, you can't say, well, I really thought it was a good idea for the company to enter into this, despite the fact that I'm lining my own pocket at the same time. Because that is a breach of the duty of loyalty. You're not putting the company's interests ahead of your own. And that was the point I was making very briefly in relation to what Lord Justice North said in O'Neill de Fowl. Because in that case, the directors, again, were just pocketing company money. And he said, well, you can't be taking a decision in good faith that that's in the interests of the company because you're conflicted. So
does that mean that the words in good faith do have an objective element, not the objective element of honesty, as you've been emphasising, but on your submission, they do have an objective element because you can't proceed in good faith in the situation where the circumstances are, in fact, objectively, such that you have a conflict of interest. Is that right?
Well, it's an evidential question, I think. I don't think it's a legal test. It's an evidential question as to whether or not the director had an interest in the outcome. So
sorry, but if you say it's an evidential question, that suggests that is an objective matter because you're looking evidentially to see if they did have an interest in the matter. That exists as objective fact. That's what evidence would show.
Yes.
And that means that the in good faith would not be satisfied.
Lord,
right?
as I said, well, I would not wish to concede that that involves an objective test. The test of lawfulness is whether the directors did or didn't decide that the action was in the best interests of the company. And the test is, did they subjectively hold that opinion? That's the test.
Yeah, but so I was asking about
yes.
What you were saying is the meaning of in good faith. And
so as I understand it, what's been suggested, I think sometimes, is that belief in good faith is actually just sort of adding a sort of strength to the belief. So you must really believe it.
Conscientiously, yes.
But as I understand it, what you're really saying is that there is a better understanding, which is that you believe without reference to your own interests. You believe disinterestedly.
Yes, exactly.
Yeah.
Yeah.
Well, suppose...
if you characterise, I'm sorry. If you characterise that as an objective element, then I'm not going to quibble over sort of labelling. But yes, that's the substance of it. I'm sorry, my lady.
Well, suppose the director thinks I'm absolutely crucial to the success of this company and I deserve a great pay rise. He puts it to the remuneration committee of the board. They say you'll get a small pay rise. And he thinks, well, that's not enough to keep me, so I'm going to supplement what they've promised me by, as you would say, helping myself the money, because I genuinely believe that that's what I'm worth, and this company would fail without me. Now, is that then acting in the best interests of the company?
You wouldn't need to worry about whether Section 172 applies to that, because the breach there would be putting yourself into a position of conflict and taking an undisclosed profit in breach of Section 317.
So you would say that wouldn't be a breach of Section 172?
Sorry. No. You don't, with the greatest respect, the whole point of itemising directors' duties under Sections 170 through to 177 is that different things fall into different boxes. Simply because somebody has done something that may be morally reprehensible doesn't necessarily mean you have to find a way of fitting it into Section 172.
Can I ask you this? If the wording had been in 172, a director of the company must act in good faith in the way he considers would be most likely, etc.
Yeah.
would you be making the same submissions?
We would. I agree the word order would be more challenging. And in fact, interestingly, as we point out in our written case, the word order was changed after the decision was taken not to introduce an objective test of honesty. Because in CLR 1, the word order was, as you've just said. And by the time we get to CLR 4, it's different. And it's in the word order that we now see.
The reason I ask that is that I would have thought it would be a significantly more difficult case for you if that had been the word order, because then it would be quite clear that good faith was referring to the Act and not to the state of mind.
Well, I agree it would be harder, but as we'll come to, that comes more into issue 1.2, which I haven't got onto yet, and word order is not the only point there, but yes, it would be harder. Only other thing we would simply say in relation to the run-up, we haven't even got to the wording of the Act yet. The only other thing we wanted to say, really two things. One is Milan and Friends says, well, the law commissions didn't always speak with one voice, and in paragraph 75 of his case, he refers to an earlier law commission report, which mentions a duty of honesty. And that earlier Law Commission report is at page 583. The relevant passage is at 583. We would just offer three very short responses on that. The first is that was a Law Commission report on shareholder remedies. It was not an analysis of directors' duties, and indeed at paragraph 1.3, it expressly stated that the scope of directors' duties was outside its remit. Secondly, as I say, we are not suggesting that dishonesty has no role to play in relation to fiduciary relationships. The discussion we're having is whether it forms the test under 172, which this footnote in the earlier Law Commission report on shareholder remedies doesn't touch on. And the third point, in response to Milan Friends' reliance on this earlier Lawcom report, is that a footnote in one report on a different topic simply cannot stand in the face of the 2 Law Commission reports and the 4 Company Law Review reports that we've been looking at. So that's the run-up to the 2006 Act. The Act itself, its avowed purpose was to undertake a thorough overhaul of company law generally. That comes from the explanatory notes at page 577. But the express purpose of the Act in relation to directors' duties was codification, not alteration of the law. Sorry, I gave you the wrong reference. Thorough overhaul. I should have given you page 2975. There being a thorough overhaul, it was obviously a perfect opportunity to introduce an objective test, if that had been Parliament's intention. But as I say, the express purpose of the Act, specifically in relation to directors' duties, was the codification, not the alteration of the existing law, and that is in the explanatory notes at page 577.
But it is intended to be a comprehensive codification.
Yeah.
Because of 170 subsection 3.
Absolutely.
So we can't fall back to any other duties owed.
Absolutely.
Because they've been replaced.
Absolutely. Quite so. So, for those reasons...
It's comprehensive in that sense, but it acknowledges that to understand what this relatively terse code means, you may have to look back at the old law. That's 170 sub 4.
Absolutely. And if you look back, you see Smith and Fawcett, the case law we've cited in our skeleton, in our written case, and Regent Crest, all of which speak with one voice, saying that the test is subjective. That's the language they use. So that's what you take as your aid to interpretation. And if you then, with that...
There is a slight wrinkle, is there not? Because very often what those cases were talking about was a different aspect of subjectivity and objectivity, which is this for the court to impose, or is it for the director's own discretion? And that might itself be described as a subjective-objective issue. So we have got that running through as well.
That is one of the aspects, I entirely agree, that is one of the aspects of what the case law is talking about. Yes, it's a matter for the director's decision, not for the court's. But, with respect, that observation only makes sense because the test is purely subjective, not objective. If the question had been, would ordinary decent people consider that this was a dishonest thing to do, it would be a question for the court. So the very fact that the court has repeatedly said it's not a matter for it under Section 172 is, in our submission, a reflection of the very point we are making, which was universally understood by practitioners, authors, and the case law before the Act was passed.
Well, I'm not sure about that. I think the two elements are actually conceptually distinct. One is talking about to what extent can you, if you like, give a margin of appreciation. To what extent do you interfere with the discretion? I think that is separate from whether or not there's a test of objective honesty.
Oh, yeah. Conceptually, they are distinct. But if the courts, as they did, repeatedly said it is not a matter for the courts, they are, with respect, espousing a purely subjective question. The only issue is, did the directors think it disinterestedly, conscientiously? So if we can then turn to the wording of the Act, we identify, knowing what we do about the case law and the professional commentary and what the law commissions and the CLR said, if we approach the Act, we submit with the assumption that it is just doing what the common law, or what the general law had already decided, which is that this is a subjective test. There are 4 elements in Section 172 which fortify that view. And if we just turn it up, it's page 548, as I imagine you already know. And the 4 elements are, first, under 172.1, the provision is that the director of a company must act in the way he considers in good faith would be most likely to promote the success of the company. The language there is, in our submission, plainly addressing the director's state of mind. The second factor which fortifies that is that A to F then list the factors to which a director must have regard. And what that means is that Section 172.1 is designed to control the decision-making by the directors by requiring them to take into account specified considerations. The control mechanism is not to impose any objective test of honesty, because that is simply not part of statutory language. And the third point on the wording of the Act is essentially the same point in relation to subsection 3. The duty imposed by this section has effect subject to any enactment or rule of law requiring directors in certain circumstances to consider or act in the interests of creditors of the company. So again, subsection 3 is designed to control the decision-making by the directors by requiring them to take into account identified factors to govern their decision-making. And the fourth point is the one we've already made in answer to a question from my Lord Burrows. The directors are required to form their opinion in good faith, which we say connotes the duty of loyalty, which itself involves a conscientious decision uninfluenced by self-interest. A couple of other very short points on statutory interpretation. The obligation under Section 172 to act in the way that the director considers is in the best interest of the company, or to most likely to promote the interest of the company, is a close cousin of Section 173, which is the obligation on a director to exercise independent judgment. And the second subsidiary point on the wording of the Act is that is in a sense
independent of whom or of what?
I'm sorry?
Independent of whom?
Independent, in a sense, it's got a rule against delegation or abdication. So independent of, for example, in some situations, a shareholder may be entitled to appoint a nominee director, but the nominee director still has to make their own mind up and not simply act as a cipher for what a large shareholder may want, for example. Or, I'm pleased to say, as is often the case, disqualified directors quite often procure somebody to become a director because they can't, and then tell the director what to do. So it's just a rule against having shadow or de facto directors. And the other point is simply to observe, and in a sense I've already made this point, that nothing would have been easier than for the draftsman to have included express wording imposing a duty of honesty to be judged by reference to objective criteria, if that had been the statutory intention. And I've already made the point that Section 174 does contain clearly, overtly, objective elements with the test of reasonableness. And I've also observed that Section 1157 itself uses the word honestly when the statutory draftsman intends that to be a relevant part of a test.
We've got the page number for...
Yes, so 174 is page 554, and Section 1157 is page 574.
So just going back to 1721, as I understand it, you say in good faith means in accordance with his duty of loyalty.
Yes, exactly.
Can I just come back to the A to F within 1721? They're all qualified by the phrase, and in doing so have regard amongst other matters too. At that point, it gets all rather objective, doesn't it? I mean, it may not affect your case, but it doesn't say what he considers in good faith would give proper regard to the likely consequences of the decision or anything. That's all appears to be in terms of whether he had regard, something which is objectively tested.
Well, slightly depends.
Just looking at
objectively tested.
Yeah.
The test, the legal test for whether he's broken his duty, is whether he did in fact take these considerations into account.
Yes.
Which is.
But that requires you to understand what he did.
Sorry, I overspoke. I'm sorry.
Forgive me. You carry on.
We would say that is a subjective test because the only determining question is what he thought, not whether the court thinks it's a good idea, whether it was a reasonable idea, or whether ordinary and decent people would consider it an honest idea. The question, the test is subjective. Did he, or she, I'm sorry, one repeatedly uses the male, did the director think? And that is a subjective test. That's what determines whether there's been a breach. Not a test of reasonableness, not a test of objective honesty. And that's why we would prefer to call that an evidential question. Has that been proved? So I've got to move on a bit quicker. We've looked at the Act. We've looked at what came before the Act. After the Act was passed, We have identified, as we say in our written case, 18 judgments which were given after the 2006 Act was passed, continuing to regard Section 172 as imposing a subjective test only. We have cited a mere 5 of them in paragraph 35 of our written case, and I don't propose to go through them. We've given you the page references. The only point I would make, and again, it is not just a tease point, but in client Earth, which is at page 3839, my learned friends successfully persuaded the court that the test was subjective. Again, it is simply a reflection of the universal understanding of the profession until this judgment in the Court of Appeal. Client Earth is page 3839, and the relevant paragraphs are 25 to 30.
Can you give me a page for those?
I'm sorry?
Can you give me a page for
Yes,
those?
paragraph 28 is page 3849.
Thank you.
So the themes that emerge from the post-2006 Act case law are absolute consistency and unanimity, and Saxon would have not identified any different views. Indeed, one of the cases that they cite for a different purpose is another example of a post-2006 Act decision in which 172 is treated as purely subjective. They referred to the case of Hamwell, Reichenbacher and McDermott. I don't ask you to go to it, but it's page 4172. They cite it in paragraph 53 of their case in support of the proposition that the question of honesty is relevant under section 1157, which is, with respect, true but self-evident because the section says so. But if you look at paragraph 57 of Hamwell Reichenbacher, paragraph 57 at page 4192, you will see that it represents another case in which the courts have treated the test under 172 as purely subjective after the 2006 Act was passed. The next category we deal with in paragraph 36 of our written case is professional commentary since the passing of the 2006 Act. And again, I'm not going to go through that. We've given you the bundle references for all the commentary, and again, we would simply observe that there is absolute consistency and unanimity among the commentators, and Saxon would have not identified any different views in the commentary before the judgment was given in this case. We make next in our written case some policy arguments as to why it is unnecessary and undesirable to introduce a test of dishonesty. I have made the relevant points in the course of answering some questions from the bench, and I don't think that I need to develop those any further on our feet. You've got those in our written case.
Can you just give me a paragraph number?
Yeah, absolutely.
37.
37?
I'm grateful, exactly so. The next point that we make in paragraph 38 to 40 of our case is simply to cite a couple of other situations where the expression good faith is used in other contexts. And I just wanted to emphasize those and respond to my learned friends' comments on them. So there are 2 points that we make. One is that in the case of Brady and Brady, which is at page 3665, the relevant passage is at 3665, I do apologize. The question in Brady was whether financial assistance had been unlawfully given, and there was a let-out under the Companies Act 1985, as it then was, if the financial assistance had been given in good faith in the interests of the company, and Lord Oliver in Brady and Brady, as I say, at 3665, letter H, says that the test is whether or not the directors held a genuine belief that it was in the interests of the company. And Malone and Friends' answer to that is, well, he didn't explain what he meant by genuine belief, to which we would respond by saying, well, he didn't need to, because it's self-evident what he meant by genuine belief. He meant, was it held? It's the subjective test. The good faith test is, well, was there a conscientious, genuine belief that the financial assistance was in the interests of the company? So there we see, within another company law context, in relation to the functions of a director, the words good faith, not importing an objective test, but a purely subjective one as to whether the directors themselves held the belief conscientiously. The other example we give for the use of the expression good faith in another context is in relation to the tort of deceit. And we mentioned Derry and Peake there, which repeatedly uses the words good faith or bona fide belief in the truth of the representation. Derry and Peake is at page 3897. And the relevant passages are in the bundle at page 3918 and 3930. Malone and Friends says, well, the law on deceit is irrelevant because under deceit the only question is, was there a genuine belief in the truth of the representation? And you don't get on to the second stage of the test in Ivy as to whether ordinary and decent people would have considered the conduct to be dishonest. But that, with respect, misses the point we are making. The point we're making is that in the context of the law on deceit, the expression bona fide belief or good faith belief is used to describe a subjective test. So where we get in our submission,
I mean, you would accept that there are other areas of the law where good faith is given an objective meaning.
yes. And there are
Often, I think, describing more conduct than states of mind. But, one thinks of good faith purchase of a value without notice.
absolutely,
Or
and
good faith change of position.
and it comes into some contractual questions too. If there's a contractual discretion, it is sometimes said that the contractual discretion has to be exercised in good faith. It takes its sense from the context. Contractual discretions, which have to be exercised in good faith, generally have to be exercised loyally to the purposes of the contract. But the cases themselves emphasize that the meaning of the expression takes its sense from the context. So that's more than all we intended to say on issue 1.1. Just to capture it, what the package that we are urging on you is that everybody, case law, professionals, practitioners, before the 2006 Act was passed, believed that Regent Crest stated the law, the test is subjective. The Law Commission and CLR reports expressly decided not to introduce an objective test of honesty. The White Paper makes clear that the purpose of the 2006 Act is to codify the pre-existing law, and the wording of Section 172 is, in our submission, clearly identifying a subjective test, and where an objective test is imposed under the Companies Act on directors, it does so expressly. So that's issue 1.1. Issue 1.2. The question under issue 1.2 is whether the obligation of good faith under section 172 applies to the director's state of mind or to his conduct. As you will be aware, the Court of Appeal has decided in paragraph 122 of its judgment that it applies to conduct. In many cases, it may not actually make any difference because most sober people don't act without having decided to do so. But the reason it matters in this case is simply because of the mismatch between the finding in the Court of Appeal and the findings of the trial judge. The finding of the trial judge was that, that my client genuinely believed that he was pursuing the company's best interests. The Court of Appeal has decided that nevertheless, by giving the board a different impression, he was acting dishonestly. So the disjunct between his motivation in acting and the honesty test of what he did does matter. So for those reasons, we submit that it is a point that arises, matters, and needs to be decided. And we have, in relation to this, a few short points, some of which we have already made. The first point is the point I was exchanging with my Lord Burrows a moment ago, namely that Section 1721 requires a director to act in what he considers in good faith, not to act in good faith. And as we say, that word order was changed when a decision was taken not to introduce an objective test of honesty.
Did the report say that it was changed for that reason, or that's just an observation?
It's an observation.
Yes, okay.
The second point is that the other provisions in sections 172, subsections 1 to 3, are similarly directed towards controlling the director's decision-making in terms of the objectives and the considerations to be taken into account. And so the provision as a whole is dealing with a director's state of mind. Thirdly, we would submit that all of that is of a piece with the duty of loyalty, the sacrifice of self-interest, which involves a subjective test.
Is it?
And fourthly...
Is it purely subjective?
Well, that is what loyalty involves. It involves choosing to act for the benefit of the beneficiary. That's what loyalty is. That is the core duty. And the fourth point is the one we've made, which is that the policy decision in CLR3, as we have already seen, was not to introduce into what became Section 172 a duty to act honestly. And the rationale for that was entirely pragmatic, as the report explained, because the commercial world is not always pretty, and decisions may have to be taken to violate a contractual obligation if a director considers that that is, in fact, in the best interests of the company.
And when they're talking about contractual obligation there, is that a contractual obligation owed by the company to some other person?
I think it is unspecific. It is a contractual obligation.
Could you give us the reference just for where
yes,
CLR
so that's
3
paragraph 3.13 of CLR 3, page 2058.
Thank you very much.
So issue 1.2 is short now that we've covered the wording of the Act and the lead up to it, and we submit that the Court of Appeal was wrong in understanding Section 172 as imposing the good faith obligation in relation to conduct. As I say, in most cases it's not going to matter, but in this case it did because of the finding of fact as to the finding of fact in the trial judgment as to my client's state of mind, but the finding of objective dishonesty in the Court of Appeal. So issue 2, can I just observe, in questions of timing, I think the timetable suggested that I would be sitting down at 5:02. but we did have a late start, so I was hoping if that's not unacceptable to carry on till 5 past, which would give me the, I think, 55 minutes I had, an hour and 55 minutes, which I had planned for.
Well, why don't you can have the 5 minutes, and if you want to use 5 minutes of your reply time, that's also acceptable.
Okay, and thank you. So issue 2, the question under issue 2, it's a compound question. Was the Court of Appeal entitled to make its own finding of dishonesty, or was the Court of Appeal entitled to substitute its own discretionary remedy? And if you haven't looked at it recently, the issue is on page 15 of the bundle. Was the Court of Appeal entitled to substitute 1, its own finding of dishonesty, and or 2, its own discretionary remedy for that ordered by the trial judge, and if not, what order should be made? As you may recall, the basis of the Court of Appeal's decision was that it was entitled to make a finding of dishonesty despite the trial judge's findings of fact, because the Court of Appeal said the trial judge had applied the wrong test. And secondly, the Court of Appeal said it was free to exercise its own discretion in relation to the appropriate remedy, because the trial judge had exercised his discretion on the basis of his finding that there had not been a breach of Section 172, whereas the Court of Appeal held that there had been a breach of Section 172, and the Court of Appeal held that there had been a breach of Section 172 for 2 reasons. First, because the Court of Appeal held that my client had acted dishonestly by objective standards, which is paragraphs 120 to 124 of the Court of Appeal judgment. And secondly, because the Court of Appeal held that my client had caused the company to act in breach of the shareholders' agreement. We submit that the Court of Appeal was wrong on both grounds in terms of its finding of a breach of 172. We say it was wrong in holding that my client was in breach of 172 on the basis that he caused the company to act in breach of the shareholders' agreement. And we say it was wrong in holding that there was a breach of Section 172 on the basis of making a finding of dishonesty. I can deal with those 2 points as briefly as possible in turn. As to the causing the company to act in breach of the shareholders' agreement, this is the point that my learned friend says falls outside the scope of the appeal. He says that permission to appeal was granted in respect only of the argument that an objective test of honesty forms no part of the duty under Section 172, and he says that permission to appeal was not granted in respect of any argument that the Court of Appeal was also wrong in finding that my client was in breach of Section 172 by causing the company not to perform its obligations under the shareholders' agreement. As to whether we are trespassing outside the scope of the appeal, we make 2 submissions. One is we're not, and secondly, if we are, we would crave indulgence to run the point in any event. The first point, we do submit that the grounds of appeal do embrace the argument that the Court of Appeal was wrong in holding that my client was in breach of Section 172 by causing the company not to comply with its obligations under the shareholders' agreement. We've already seen what the basis of the Court of Appeal's judgment was. If you turn up page 521 of the bundle, you will see the grounds of appeal. And you'll see that the appeal had 2 elements. 1.1, the legal test for breach of director's duty under Section 172. That is the point that is common ground. 2, I acknowledge that it does start with the word consequentially, but the substance of what 2 says is the conclusion that Mr. Costa had breached his 172 duty was the basis of the Court of Appeal's decision to substitute an unconditional buyout order for the conditional buyout order made by the trial judge. If, as Mr. Costa respectfully submits, the Court of Appeal's conclusion on breach of Section 172 was wrong, that substitution cannot stand, and the judge's conditional order should be reinstated. So, barring the word consequentially, which I admit is unhelpful for my argument here, the substance of what subparagraph 2 is saying is the Court of Appeal was wrong to find a breach of Section 172. And it found there was a breach of 172 for two reasons.
But is that then reflected in the detail which follows?
The argument about whether the Court of Appeal was right in finding that there was a breach for causing non-compliance with the shareholders' agreement is not expanded. No, I accept that. But the point is clarified. We submit further in paragraph 2, where my client identifies the points that are not being appealed. And he does not say that he's not appealing the finding that he was in breach of 172 for having caused the company to act in breach of its own.
Were you seeking that there should be no relief whatsoever, or were you seeking to go back to the judge's decision that there should be a subsequent trial as to whether they would have got an offer of?
That's right. We were the latter. We were saying we should go back to the judge's decision. That could only come about if we satisfied satisfied this court that the Court of Appeal was wrong to find that there was a breach of Section 172, because the basis upon which it substituted its own decision was that it found there had been a breach of 172, and it found that on two grounds. So if we were only appealing in relation to the dishonesty issue, the question of setting aside the Court of Appeal's exercise of its discretion couldn't have arisen.
No, but the judge's decision was based on the finding that the breach of 172, I think, was causing the breach of clause 6.2, and that is why it was a sort of breach of contract.
No. So, with respect, the judge found that my client had caused the company to act in breach of the shareholders' agreement. He did not find that that meant that my client was in breach of his duty under 172. So, the Court of Appeal, it's paragraphs 125 to 128, the Court of Appeal reversed his finding and said, by causing the company not to comply with its contractual obligations, the judge should have found my client was in breach of his duty under 172. It was causing the company to act in breach of its contractual obligations, the Court of Appeal said, is a breach of 172.
Did it work quite like that? I thought it was more that the SHA, I'm looking at paragraph 125 on page 122, it was an agreement by which the company and all the members had identified their objectives during the time when the members were invested in the companies. So I had rather read that as the Court of Appeal saying, well, the SHA was, if you like, a crystallised, agreed statement of objectives for the company and what the relevant people would regard as being in the best interest of the company and its members.
Yes, but if one reads the whole of 125 to 128, what the Court of Appeal goes on to say is, because in their view, the shareholders' agreement identified the success of the company, by into the last couple of lines of 126, maybe the shortest way of getting it. In short, because Mr. Costa knew that what he was doing was contrary to what the investors had defined as their terms, as it defines their interests in this SHA, that was a breach of his fiduciary duty under 172. So by causing the company to act in breach of the shareholders' agreement, he was in breach of Section 172.
Right. There may not be much between what you and I are saying, but again, it seemed to me that the reasoning of the Court of Appeal was you treat the SHA as a sort of crystallised statement of what the relevant people regard as being in the best interest of the company, and Mr. Costa acted contrary to that. Is that not an appropriate way of putting it?
Well, if you just look at page 123, paragraph 132 and 133,
Yes.
where the court says they entirely see the argument that if all that had occurred was that Mr. Costa had in good faith caused the company to breach Article 6.2 of the shareholder agreement, then it might have been appropriate for the judge to grant relief designed to replicate the position that Saxon would have been in had it brought a breach of contract claim. However, we consider that the position is fundamentally different as a result of our conclusion that Mr. Costa had not only caused the company to act in breach of contract, but had also acted in breaches of agreements under Section 172. So the reason they're substituting their discretion is because they made a finding of a breach of 172, which the trial judge didn't make. And they're making a finding of breach of Section 172 on two grounds. One is their finding of dishonesty, and the other is causing a breach of the shareholders' agreement.
But what was the basis on which they granted a personal remedy against Mr. Costa if it wasn't that he breached 172 by causing the company to breach 6.2?
What was the basis on which who ordered against him?
The court, didn't
The court, the trial judge or the Court of Appeal, sorry.
Didn't the
Because
trial
the trial judge deals with this by saying, well, Mr. Costa is not, in fact, a shareholder, and he's not personally, I think, a party to the shareholders' agreement. But because he de facto controlled what the company did, he caused the company not to comply with its contractual obligations under the shareholders' agreement, and therefore it is appropriate to make an order, a personal remedy order against him. That was the trial judge's reasoning.
not because he had breached any duty.
No, exactly. The Court of Appeal finds that there has been a breach of 172 on the basis of their finding of dishonesty and a finding that the breach of the shareholders' agreement involved a breach of 172 as well. So, sorry, that's all a long introduction to the submission. First, that the appeal could only coherently ask this court to set aside the exercise by the Court of Appeal of its discretion on the basis that we were appealing the totality of the Court of Appeal's finding as to breach of 172. Otherwise, we would inevitably lose if we were only appealing one aspect of that finding. Alternatively, as I say, we had 2 points as to why we're allowed to run the argument. The alternative is, if you take the view that it's not within the scope of the appeal.
Oh, sorry, I'm so sorry, but just on the first one, I mean, you can breach Section 172 in lots of different ways, and they'll have different significance potentially. So I'm not sure it's, if I may say so, it's good enough just to say, well, our case is based on contesting what the Court of Appeal determined in relation to Section 172, where we know that they determined breach of Section 172 on 2 bases, and you seem only to have identified 1 basis that you're taking issue with.
No, I'm sorry, I must have made myself unclear. We are appealing against both the Court of Appeal's ability to make a finding of dishonesty and the Court of Appeal's finding that by causing the company to act in breach of the shareholders' agreement, Mr. Costa also acted in breach of Section 172. We're appealing on both of those. We are unquestionably appealing on the first.
Yes.
The only issue I'm addressing you on is, are we also appealing on the second?
Yes, and well, I think I had understood that.
Oh, I'm sorry.
And I thought that you were struggling with the word consequentially
Yeah.
in relation to number 2,
Yeah.
and struggling with the fact that in the body of the notice of appeal, issue is not distinctly taken with the part of the Court of Appeal's reasoning based on breach of the shareholder agreement.
Yeah.
But you are saying, well, we must be taken to have covered that aspect of breach of Section 172 as well. And the only reason I piped up was because you said, well, we must inevitably have been asking that because we're contesting what the Court of Appeal did in relation to Section 172. And if we were not contesting the part of their reasoning in relation to Section 172 based on breach of the shareholder agreement, we would necessarily lose the appeal. And I was, the reason I then spoke was, it seemed to me that that reasoning, with respect, that doesn't seem right, because you can breach section 172 in different ways.
Yeah.
There are two ways that have been identified, and reading your grounds of appeal, it seemed to take issue only with one of those, or so it might be said, and not both.
Yeah.
And it does make a difference which one's relying on, because they can have different significance in terms of the exercise of discretion under section 994.
I'm sorry, I hadn't intended to take so long on this. The point I had been intending to make was that we were, in paragraph 1(2) of the grounds of appeal, we say at the end, if Mr. Costa respectfully submits the Court of Appeal's conclusion on breach of 172 was wrong, indiscriminately.
Right, okay, all right.
That substitution, i.e. of its discretion, cannot stand. We could only say that the substitution of its discretion cannot stand if it was entirely wrong on section 172, because if we weren't appealing on the finding of a breach of 172 in relation to the breach of the shareholders' agreement, then it would have been able to say, the Court of Appeal would have been able to say that that the trial judge took his decision on a false basis because he had found no breach of 172.
Yes, thank you.
The alternative is to crave your indulgence and run the point because it's a point of law of which ample notice has been given. My learned friend has answered it in his written case, and he'll have an opportunity to answer it in oral argument. I am now extremely short of time in which to develop the argument. The points that we would simply make in relation to the finding by the Court of Appeal that a breach, that causing the company to act in breach of the shareholders' agreement necessarily involves a breach of section 172, in our submission is formulaic and ignores the undoubted subjective element in the test. The question is, did Mr. Costa believe, consider, bona fide, that deferring the exit was in the best interests of the company? He may have been wrong, but if he believed it, then he's not in breach. Sub silentio, the Court of Appeal have simply imposed a purely objective test, not even of dishonesty, but just saying the shareholders' agreement defines success of the company, ergo not pursuing it as a breach of 172. And in our submission, that is just logically unsustainable. The finding of dishonesty is the other point which I had intended to address at greater detail. But we touched on it to some extent. We submit that the Court of Appeal was not entitled to make a finding of dishonesty. First of all, as you know, because we say it is irrelevant under section 172. Secondly, because the Court of Appeal did not give due weight to the nuanced findings by the trial judge, which are set out in paragraphs 56 and 57 of our written case. The Court of Appeal simply took one line about the board being misled and treated that as the basis for acting. It did not, the Court of Appeal did not appear to take into account, as regards Mr. Costa's state of mind, the fact that he genuinely believed that what he was doing was in the best interests of the company. And my learned friend is wrong to say that the trial judge's finding amounted to a finding of a breach of a contractual obligation of good faith. What the trial judge did, and if the Court of Appeal proceeded on the belief that that was what the trial judge had done, it was wrong because the trial judge clearly made a finding that my client was not acting in bad faith and that he genuinely believed in the rightness of what he was doing. You've got the references in the main judgment. The only other thing I'd draw your attention to is the consequentials judgment.
But what you don't say that what the court, you say that it's not right to say that the Court of Appeal overturned the judge's finding of his genuine belief on the basis that it was, any such finding was inconsistent with the facts as found.
We say that the Court of Appeal did not take properly into account the nuanced elements of the judge's factual findings. For example, paragraph 200 of the trial judgment. The trial judge says, Mr. Costa pursued on behalf of the company a strategy which he knew or should have known was contrary to the obligations of the company. That's page 212. There isn't there an unequivocal finding that he did know that what was being done was in breach of what the judge found to be the contractual meaning of the shareholders' agreement. There was argument at trial about the true interpretation of the shareholders' agreement, with which we do not need to trouble you, but there was a debate about whether what had to happen was working towards an exit or effectively trying to conclude an exit before the end of the calendar year.
And you lost on that.
We lost on that as a matter of interpretation. But what the trial judge does there is to make an equivocal finding. And that was reflected in the way that my learned friend put his case in the Court of Appeal. His own skeleton said, paragraph 26 of his skeleton in the Court of Appeal 505, adopted the same language. He said that the trial judge's finding was that Mr. Costa knew or should have known that there was a breach. Now, that doesn't feature in the Court of Appeal's judgment. So when the Court of Appeal is doing the two-part IV test, what did my client think? And secondly, would ordinary decent people think what he did was dishonest? First of all, it's got to have a fully informed understanding of what the trial judge found. And the trial judge did not find anywhere that my client decided to mislead the board. Many of the findings in the trial judgment are actually directed towards showing that my client was excluding other directors from contact with the bankers, Jeffreys, but not that he was misleading them. And it's not as if my client or Jeffreys, the bankers, were doing nothing. And it's not as if my client was excluding all of the directors from the process. And indeed, there are many findings in the trial judgment which show that my client had actually made no secret of the fact that he believed that the company simply wasn't ready to be sold. If you look at paragraphs, particularly paragraphs 55
that was
and
clearly his view, as my Lord Briggs was saying at the outset. What he may have been misleading them was into thinking, yes, we know that his view, but he's going along with the majority view rather than ploughing his own
yeah.
furrow.
But again, the trial judge's findings on that are much more equivocal than the Court of Appeal found. If you look at paragraph 202, at the bottom of page 213, in giving his fellow directors a different impression, he misled the board. There is a dearth of primary factual findings about actual misleading. So there's a lot of detail. I'm going to have to stop, but there's a lot of detail in our written case, in the footnotes and the references, as to what the trial judge was actually saying. It's not a simple story of my client doing nothing and lying. The lie that my client was accused of was that he had some covert plan not to sell the company at all, because he wanted to create some spring media ecosystem. That was the nefarious plan which the trial judge rejected. That was the lie that my client was accused of, and that's what the trial judge deals with in paragraph 4 of his judgment. What was left was essentially a complaint of exclusion from the process, as one sees in paragraph 104. So I've taken that last point at a bit of a canter, but I think that's all sensibly I've got time for now.
Yes.
I'm grateful.
Yes. So that is 5 minutes of your reply. He's not, but we understand that. Yes, very well. So, Mr. Davis.
My lady.
Can I just indicate, so there's a fair distribution of the time lost, we'll sit till 1:05, so, and it's 5 minutes lost on the reply, so you can take that into account.
Thank you, Madam. I appear for the respondent to this appeal, Saxon Woods, together with Mr. Rivet. Mr. Rivet will be addressing you later on the subject of the various reports of the Law Commission and the Company Law Review Steering Group on which the appellant relies. I'll be dealing with the other issues that arise on this appeal. And clearly those issues include issues of principle regarding the meaning and effect of Section 172. But before turning to the issues of principle, I'm going to spend a bit of time on the facts and findings in this particular case in the courts below. Starting with the first instance judgment, which I think we've just been referring to. Judgment, if you'd be kind enough to turn it up, is at the page 132 in the key documents. And I just want to focus on the key findings so that you have these very clearly. Firstly, if we go to paragraph 200.
Which page?
It's page 212. Bundle. And you see at the start of that paragraph, as I have found, the reason that the company breached its obligations under the SHA was that it entrusted the conduct of the sale process exclusively to Mr. Costa, and Mr. Costa did not conduct that process in accordance with the obligations of the company. A point arose earlier on as to whether or not there had been a decision of the board to commence the exit process. There certainly was, and an exit committee was appointed, and the relevant paragraphs, you don't need to look at them now, but they're paragraphs 37 and 38 give some of the background to the board meetings when that was dealt with. And then just carrying on in paragraph 200, on page 212 of the bundle, you can see reference to Mr. Loy having complained to Mr. Costa that the process was not being conducted properly. And then at the bottom of the paragraph, the last two sentences, as a result of all of this, Mr. Costa pursued on behalf of the company a strategy which he knew or should have known was contrary to the obligations of the company, and in particular contrary to its commitments to Mr. Loy. I think it's clear that as a result of this, the company was in breach of its obligations. So there's a clear finding that Mr. Costa was responsible for the breaches. Then if we go to paragraph 202, just a little bit below.
So did you want to say anything about the point on that paragraph emphasised by Mr. Crowe, that a strategy which he knew or should have known, that there isn't an unequivocal finding of subjective awareness?
My Lord, I'll come to the subjective, objective point in due course, if I may. But right. That's clearly what the judge doesn't make an absolutely clear finding as to his subjective mindset at that point. I accept that.
Sorry.
But what we do see in paragraph 202 is the judge dealing with the interactions with the board and the updates to the board. And if you'd be kind enough just to cast your eyes down through that paragraph, you see towards the bottom over the page on 212, Mr. Costa and Mr. Uberoy were therefore the only people in a position to know both about the scope of Jeffrey's mandate and about the company's obligations under 6.2, and therefore to realise that what Jeffreys were engaged in was absolutely not working in good faith towards an exit no later than the 31st December 2019. In giving their fellow directors a different impression, they misled the board. So we say there's a clear finding there that Mr. Costa misled the board, or indeed all of the board except for Mr. Uberoy. Then if we turn to paragraph 225 of the judgment, which is on page...
So where was the bit about misleading the... Oh, I've got it. It's the bottom of page
I beg your pardon, yes, it's
213.
That's right, towards the bottom of a very long paragraph.
Yeah.
And then the next paragraph of the judgment I want to show you is paragraph 225, which is page 220 of the bundle. And again, about 9 or 10 lines down in paragraph 225, you see, it is clear that this is the case. Mr. Costa had sole control of the process relating to the company's compliance with its obligations under clause 6.2 and appears to have consistently reported to the board that these obligations were in fact being complied with when he knew they were not. So we say that is also a clear finding that he's misleading the board.
So it doesn't say when he knew or should have known that they were not.
No.
That says he knew that they were not.
He knew, and the previous paragraph says he misled the board. So, and not only once, but it's described as consistently. So it's deliberate and repeated misleading of the other directors of the company. And just if we read on in this paragraph, we see in this regard it is significant that his most strenuous efforts were directed towards ensuring that no other director had any information at all about the process other than what Mr. Costa chose to provide. And there's a similar finding, actually, if we go back to paragraph 165 of the judgment, which is on page 195 of the bundle. And
Perhaps it's a small point, but just over the page on paragraph 225, he says Mr. Uberoy clearly assisted him in his design. I mean, I think design indicates
strategy.
A deliberate, conscious strategy. Yeah.
My lord, yes.
Sorry, and you were taking...
I was going just to make a similar point. This is on Mr. Costa controlling the information, and this is page 195 of the bundle, paragraph 100, at the bottom of paragraph 165. And you'll see the last sentence. For Mr. Costa's perspective, I beg your pardon, what we have in 166 is, to my Lord Sale's point, I think that Mr. Costa's delaying tactics. So again, it's a strategy being employed, which is deliberate conduct.
But sorry, did you want something in 165 as well?
Actually, 163, I think, forgive me, I had the wrong reference. It's page 193. And if you see the second sentence of 163, his primary focus at all times appears to have been to ensure that no director or shareholder other than Mr. Uberoy had any knowledge of or involvement in the exit process. So what we have from these findings is it's not just a case of Mr. Costa misleading the board. He was actively preventing other directors from finding out the true position. And the true position was that he was ensuring that the clause 6.2 exit process was not being followed. Now, nonetheless, the judge...
Was it ever any part of your pleading case that, having been entrusted with giving effect to the clause 6.2 obligation, he went to do exactly the opposite? Was itself a breach of duty, regardless of section 172?
It was relied upon as a 172 breach.
Yes, but it was never, as I understand, it wasn't relied on as a separate breach. I mean, just a breach of the trust that was reposed in him by his fellow directors.
No, it was put in terms of director's duty, my lord. So regardless of that, what we have is the judge finding that this did not give rise to a breach of 172, and his reasoning is at paragraph 208 of the judgment, which is page 215 of the bundle. And again, it's 10 lines or so down in paragraph 208. What the judge says is, I do not believe that it was his intention by doing this actively to injure either the company or any investor. I think that his state of mind might be summarised as inverted commas, they wouldn't like it now if they knew, but they will thank me in the long run. Put another way, I think Mr. Costa did sincerely believe he was acting in the best interest of the company and its investors. So again, that language, they wouldn't like it now if they knew, but they'll thank me in the long run, is redolent of a deliberate strategy, being to keep the other directors in the dark, whilst he pursues a plan that is in fact causing the company to breach its own obligations. Now, of course, in the events that happened, Mr. Costa's actions had serious adverse consequences for the other investors, including Saxon Woods, because COVID came along, and due to the delay, the company hadn't been properly marketed and a sale achieved prior to that. And we see reference to that in paragraph 253 of the judgment, which is at page 233. And so in paragraph 253, under the heading Consequences, the judge says, so where does this all leave us? The key point is that Mr. Costa's gamble that the company would significantly increase its value if its sale were deferred for 12 months or so spectacularly failed because of the onset of COVID. So that's the key findings in respect of breach, we say. And the key result, the key question of principle that's crystallised is, does the Section 172 duty permit a director deliberately to mislead his fellow directors if he or she considers that this is desirable for the purposes of promoting the success of the company? And the answer to that question turns on the meaning and effect of the words in good faith, as they appear in Section 172. Now, I'll obviously come on to deal with that in full, but whilst we are looking at the first instance judgment, there's one other point I wish to make at this stage. And this is as follows. Both in his written and his oral submissions, my learned friend tries to explain the purpose of the words in good faith in Section 172 as purely and simply directed to ensuring that the decision-making of a director is not influenced by self-interest. We say that's wrong. Confining the meaning of good faith merely to the avoidance of self-interest does not adequately capture the meaning and effect of those words, as I'll come to explain. But the point I'm currently making is that even if one were to accept for a moment that the words in good faith are only concerned with preventing self-interested decisions, it is clear that Mr. Costa was acting in his self-interest. And that's clear from the judgment. And we see that at paragraph 165. Sorry, I'm jumping around a little bit, but if we go back to paragraph 165, which is on page 194, now what we see in 165 is the judge explaining in some detail Mr. Costa's thinking. So he describes Costa as a financial investor seeking a return. He believed that if the sale was deferred until an EBITDA figure could be got to $9 million, the sale value of the company as a whole could have been got to $150 million. But he knew that other investors wanted to sell. He refers to Mr. Loy and Mr. Flamini, and they in fact controlled a majority of the shares at that point. And if they agreed to sell for $90 million, the effect of the drag-along provisions of the SHA would have compelled him, Mr. Costa, to offer his shares at the same price to the purchaser. And if we turn over the page, and you can read down, but it's really the last sentence of paragraph 165. For Mr. Costa's perspective, almost the worst possible outcome would have been a firm offer in late 2019 to purchase the company for £100 million, capable of being accepted by the shareholders. So the judge identifies very clearly that the last thing Costa wants is to comply with clause 6.2, and then you see in paragraph 166, that's where we get this comment about delaying tactics. So a deliberate strategy to delay the sale in his own self-interest to avoid what for him would have been the worst possible outcome.
And his belief that they would actually thank him because they would get more money They may or may not, depending on why they wanted to take their money out. They may have had something else better that they wanted to do with it, which they were prevented.
My lady, I entirely agree. So we say, in short, it's clear from the judgment that the judge considered that Mr. Costa was influenced by self-interest. If there was any doubt about that, we see the judge's further comment in paragraph 208 of the judgment. And further on, so that's
215.
at page 215. We've looked at part of this paragraph. This is the paragraph which has the finding about misleading, thanking them in the long run, bottom. But a little bit further up, halfway down the paragraph, you see the judge saying in terms, he also perceived that his personal interests as a shareholder were best served by delay. So,
But that's in the context of a paragraph which starts by saying his position was he believed it was the best interest of the company's shareholders, by which I think he means all the shareholders, not to comply with 6.2, which the judge
Knew they disagreed.
so he's saying two things at least.
I think he's saying, isn't he, that his personal interest ran hand in hand with the interests of all the shareholders, rather than that there was some conflict, as you like, between the differing interests of the different shareholders.
My lord, I agree.
I mean, he's asserting that as, the judge starts by saying that was his position, but reading 208 as a whole, I'm not sure that the judge
Well, there's
says
a
that wasn't the true
difference.
position.
Well, my lord, I'm not making a point about conflict at this point.
No, I know.
What I'm saying is...
You are saying he was in breach, he was not in good faith because he was motivated by self-interest.
Well, my lord, it's my learned friend's explanation for the meaning and effect of in good faith in section 172, is that it's purely and simply directed to ensuring that decisions are not influenced by self-interest. And here we have a finding in this very judgment that must be taken to the effect that Mr. Costa was influenced by self-interest. So the long and short of it is that even if my learned friend's right, and he's not right, about the meaning and effect of good faith, if one actually looks at the judgment, he fails anyway.
Well, that issue was never specifically addressed by the judge or the Court of Appeal.
My lord, it's only an argument that's emerged in the context of this very appeal, the idea that good faith should be interpreted in this very constrained fashion. And my response to that is, well, if that's what you want to consider, you do actually need to consider the findings that were actually made. And so even that interpretation is not going to help you in this particular case. I accept that.
As I understand the submission, it's built from the idea of a duty of loyalty.
Yes.
And as I understand it, what is therefore being said about not acting in your own self-interest, assuming that that is a conflict of interest.
Well, no. The way it's put in their written case is it's influenced by self-interest. And that's deliberate because, of course, if it was a conflict, it would be caught by other duties in any event, and it wouldn't really afford an adequate explanation for the words good faith in 172.
So, which is the paragraph in the appellant's case, please?
It's paragraph 33.4, I think. I'm going to come to it in more detail. But what I'm trying to demonstrate at this one is just by reference, on my learned friend's own terms, the judgment, unfortunately for him, will not allow his appeal to succeed.
Because he assumed that the other shareholders would be glad if they got more money at the end.
Yes.
Whereas actually they might have said, well, we don't want that more money. If we'd had our money out when we should have had it, we would have invested in that thing and we would have made double.
And also because there are findings that he was influenced by his self-interest at the same time.
So he convinces himself that his interests are the same interests
Yes.
as the other shareholders.
And that's a breach, and it's a breach on my learned friend's case anyway. So what they also rely upon is the finding of dishonesty, or the statements in respect to dishonesty that are made by the judge very early on in his judgment. And I just want to deal with that quite quickly, if I may. It's paragraph 4 of...
So you would say, sorry, just to follow up this point, you would say that logically we'd then be talking about section 175,
Yes.
which duty to avoid conflict of
Yes, it's quite deliberate, I imagine, why they've framed it in paragraph 33.4 as influenced by good faith. Because otherwise, if it's a conflict of interest, if he's pursuing his own interests and preference to the company, that's dealt with by other duties. So it would still leave me being able to say, well, what you are saying is it doesn't give good faith in 172 any proper meaning or effect. It doesn't actually advance matters. So they've broadened it to say influenced by self-interest in an attempt to give some substance to the words on their interpretation, which only operate on the thinking of the director. I'll come on to explain why we say that doesn't work in any event, but the short point for present purposes is it certainly doesn't work on the facts of this case as found by the judge.
But are you saying that Section 172 means that every time a director has regard to how he will do, well or badly, as a shareholder in deciding what's best for the company, he's in breach of the good faith aspect of 172?
My lord, no, that's what my learned friend is saying.
That would be a remarkable position.
That's what my learned friend is saying. That's why it's remarkable and it doesn't work. My learned friend's explanation for good faith is that it is designed to prevent any influence of self-interest in a decision. We say that doesn't work on any kind of analysis.
Any director who's got shares in the company is going to have a personal interest in the company doing well.
And quite frequently, the personal interests of the director and the interests of the company will be completely aligned. And the idea that you can, frankly, police a duty that would require one to check that any decision by a director had not been influenced by his self-interest is hopelessly impracticable. Personal interests are obviously important when they conflict and where a director pursues his personal interest in preference to the company's interests. That would be a breach of 172 anyway, because you would not be promoting the success of the company. And it would also be covered by Section 175 potentially, or Section 177. But none of this is an adequate explanation for the meaning of the words in good faith. But I will come to deal with that in more detail. Just turning back to the judgment, paragraph 4 is where we find the judge's statements about dishonesty. And there is some discontent on the other side about the Court of Appeal, it is said, overturning the judge's finding that the directors were not, that Mr. Costa was not dishonest. What I say to that is it's not really a finding. Certainly not. It's more of an observation as regards the case theories that were put by both sides about the key protagonists being behaving badly, and the judge wasn't prepared to accept either case theory. And you see him observe on page 134 that I don't consider either of them to have been dishonest. But he's certainly not considering the meaning and effect of Section 172. He's not considering the meaning and effect of the words in good faith. And of course, I've shown you the findings he does make about Mr. Costa misleading the board and acting in his own self-interest. So I would suggest that the judge's comments here, and there's not much analysis with respect, are to be treated with a great degree of caution. So just to conclude on this brief review of the judgment, what it shows is the following. Mr. Costa deliberately misled the board. He did so in the knowledge that some of the directors would disagree with what he was doing. He also deliberately prevented other directors from finding out the true position, and he acted in his own self-interest. At the risk of understatement, it would be remarkable if that conduct could be squared with any duty that required good faith. Now, my learned friend referred a couple of times to the universal understanding of the profession about the duty being subjective, and I'll come on to what we mean by subjective. But I would suggest it would have been the universal understanding of the profession that it would constitute a breach of duty by a director to mislead deliberately his fellow directors. Now, just quickly on the Court of Appeal, the judgment there is at page 96 of the key documents bundle.
966.
96.
96, thank you.
And you can see the Court of Appeal identify the issues in the case at paragraph 50, and that is at page 108. And there are 6 issues. The first 2 are the issues of construction, clause 6.2. The third issue is whether that there was unfair prejudice as a result of the breach of clause 6.2. The fourth issue is whether Mr. Costa had breached his duty under section 172, which of course is the central issue on this appeal. And the fifth and sixth issues concern relief. And on relief, the question was whether or not the judge had been correct to impose a condition on the buyout, as opposed to the normal position, which is an unconditional buyout. Now, the findings start at paragraph 62, so pages, if you turn over to page 110, you'll see there the findings in respect of the construction points on which the petitioner Saxon Woods prevailed. And then the third issue we see at paragraph 94, beg your pardon, paragraph 86, starts with, was it unfairly prejudicial to breach? And the conclusion is that it was unfairly prejudicial, and that's dealt with at paragraph 94. So the actual causing the breach was unfair prejudice. But as we see in paragraph 96, that still leaves the question of relief. And the Court of Appeal wanted to deal with the question of breach of fiduciary duty before deciding whether or not it was appropriate to order an unconditional buyout order. And so they move on to deal with breach of fiduciary duty. And we see the analysis in the paragraphs from 97 onwards. Paragraph 99 recites the key finding of the judge, on page 116 of the bundle. And then in paragraph 10, you can see that we argued that the judge's conclusion that there was no breach was wrong on 2 fronts. And paragraph 101 is the first way in which we say there was a breach of the duty. And this arises from Mr. Costa having been found to have deliberately breached clause 6.2 of the shareholders' agreement. That was obviously the clause that required good faith efforts to be made towards the sale of the company by the end of 2019. And we argued that simply by virtue of the fact that he had caused the breach of that duty, that obligation, that was incompatible with his duty under section 172. And that's because all the company's members and the company itself had agreed under clause 6.2 that they should be seeking to sell the company by the end of 2019. And in so doing, they had effectively defined what success of the company, in the words of 172, looked like. So it was not open to Mr. Costa, consistently with his duty under section 172, to seek to frustrate the achievement of that objective. Now, this argument for breach does not depend upon the meaning and effect of the words in good faith. It's quite separate. It was simply that where the members and the company have all agreed what should happen, it's not open to an individual director to override that agreement. The Court of Appeal agreed, and their conclusions are at paragraph 125 to 126. You see that on page 100.
Sorry, why do you say that this argument doesn't depend on the words in good faith? I mean, if the words in good faith weren't there in section 172.1, it would read as a completely subjective test depending on what the director considers would promote the success of the company.
My Lord, yes, but there's a question of what is the success of the company? And we say that is subject to some objective limit.
Sorry, why do you say that, just as a matter of interpretation of section 172?
Well, because the court is entitled to determine objectively what the success of the company is by reference to what has happened. And in this case, all of the members and indeed the company itself, have decided upon what the company
But
should be
Mr.
doing.
Costa doesn't agree with that. So
Well-
if one doesn't have the words in good faith in section 172, and it is a purely subjective test, I'm struggling to see why somehow you say that Mr. Costa is in some sense subjectively bound by what has been written down in the shareholder agreement as defining the best interest of the company if he doesn't agree with it.
Well, Lord, perhaps it will assist to look at one reference, if I may.
Yes, certainly. Yeah.
It's in the academic materials, so it's at page 5734, I beg your pardon, 5731, it's Palmer's company law, and it's page 5732 specifically. And there we have some commentary on subsection 1 of section 172. And you see subheading subsection 1,
Yeah.
and there's reference, this subsection enshrines a number of important elements. One, the success of the company for the benefit of its members as a whole. There's some discussion about why that was chosen in preference to the old common law formulation of in the best interests of the company. And then there's reference to the primacy of the company is significant. And then there's Roman 2, directs the members to decide what success means. Directors' good faith business judgments must be calculated to promote the success of the company. Success is to be determined on a company-by-company basis. The Attorney General, Lord Goldsmith, explained further, the starting point is that it is essentially for the members of the company to define the objectives that they wish to achieve. Success means what the members collectively want the company to achieve. So, my Lord Sales, that, I think, goes to your point. I'm not sure if it adequately answers the question on specifically on the construction of the words in the section.
Well, it seems to me it's a very important point because of the list of factors to which the directors must have regard, which include things that might be regarded as in conflict with each other. So if the members tell the directors, we actually want to make sure our money is invested ethically, we want to pay all our bills promptly, we want to have as little environmental impact as we can running the business, I think you would say it's not for a director to say, well, I think the company will make more money if actually we delay paying our contractors until they sue us, or we pay our employees only the minimum wage, or do those things. That it may make more money, but that's not what the members have defined as being the best interests of the company, taking into account those factors. Would that be?
My lady, I agree. Standing back, it would be an extraordinary thing if a single director could proactively seek to frustrate what all of the members, and indeed the company itself, have bound themselves to as regards the strategy, objectives, whatever it may be, to be pursued by the company.
Aren't there two stages in this? The director is required to form his own independent judgment, and he may, sometime after the shareholders have laid down these objectives, conclude that those objectives are not, in his independent view, consistent with the company's best prospects of success. To that extent, he's not required to shut out from his mind that some objectives other than those chosen by the shareholders might be better for the company. But then the second question is, if he does form that view, namely that the shareholders have got it wrong, what does he do then? And it seems to me that then there's a very big question as whether he has to go back to the board first, probably, and then probably to the shareholders and say, look, actually, whatever you may have thought when you decided this, it's going to lead to a disaster. But not to try and achieve the alternative objective behind their back.
My lord, that must be right, with the greatest of respect. I emphasise this is an unusual situation because...
The reason I asked my question was I follow the points being made by my lady and my lord. My question really was directed to the point you were making, that if the words in good faith weren't there, it would make no difference. And at the moment, I could see arguments as to how there may be space for the sorts of points that my lord and my lady have been making in the words in good faith. But if they weren't there, I am still struggling to see quite how it would be anything other than a purely subjective approach for the director who, if those words weren't there, would be entitled to say, well, I don't really care very much about your shareholder agreement because I don't agree with it.
So, my lord, forgive me, but I didn't mean to put it in terms of if the words were not there.
Right.
My
You
point,
did say the argument does not depend on the words in good faith. Well, that's what I mean.
that's rather more what I mean, in the sense that the focus of this breach is not on the words in good faith and their meaning. The focus of this breach is on what we mean by success of the company. So it's more a question of where we're focusing this breach, and this breach is not concerned with me having to argue about the meaning and effect of in good faith, particularly.
But then why aren't you bound by the judge's finding at paragraph 208 that Mr. Costa genuinely thought that the best interests of the company were to delay matters?
Because what we say is as a matter of law, and this is how Section 172 has to be construed, that if all of the members and the company have agreed that as what the success of the company is, it must be a breach of the director's duty under 172 to seek to undermine that. That is our simple proposition. But in saying that, I wanted to come on to say this is an unusual case, because this is a case of a contract between all of the members of the company and the company itself. It's a very unusual, in that sense, an unusual situation. It's not a normal contract. And ordinarily, a director has a very broad discretion as to what the success of the company means and how it is to be achieved. Hence, we have all of the case law that my learned friend refers to about it being a subjective test, because, of course, in 99 cases out of 100, we don't have a situation where the company itself has already told everybody and bound itself to what the success of the company is. This makes this aspect of this case is unusual. Ordinarily, there's a very broad discretion in a director to decide on this part of 172.
I have to say that when you say it must be a breach of 172, I think our concern is how do you get there on the wording? Now, if you say, well, it's not turning on in good faith, it looks problematic.
Well, my lord, if I need good faith, I'll rely upon it. I mean, I think my point was the focus of this particular breach is not really on that, what we've heard my learned friend developing at great length, the arguments about in good faith. The focus of this breach is on what we mean by success of the company. But
I have to say I am following this part of your submission, finding it difficult to follow, because of the findings made by the trial judge about the subjective state of mind of Mr. Costa, that he genuinely thought didn't matter what was in the shareholders' agreement. That's all a bad idea. The company's best interest will be promoted through delay and not following through the shareholders' agreement.
Well, my lord, I will say that it was not capable. He was not capable of reaching that decision in good faith, in circumstances where the company had determined and bound itself to what was to happen. So I will rely upon the words in good faith.
I think the good faith gets you to my lord's second point, which is if you do genuinely form the view that what the company and the members collectively have decided success looks like, then before you act on that, on the contrary, good faith requires you to go and try and persuade them to your point of view and abide by whether you succeed or not.
I mean, that would be true whether it was a shareholder decision or, for that matter, a board decision.
And here we have both. because the board had decided to commence the exit process. So
My problem with your submission that the director can sort of be bound by the shareholders' view about the success of the company is section 172.1 talks about what he considers, and then he is to exercise his own independent judgment. It seems to me when shareholders make an agreement in July, let's say, that's what we want this company to do. But by October, the director who's there all the time, and he's their guardian of the company and meant to keep an eye out as to what's going on, can see that the weather's changed and they ought to be doing something different. He's not bound by what they've decided 3 months previously. He must exercise his judgment, his own independent judgment now as to what the best interests of the company are, or the success of the company should be. I know it's success of, not best interests.
So, my Lord, I take that point. My focus was on emphasising the rather extreme facts here.
Yes.
We do have a contract that the company has agreed to, the members have agreed to, and all the directors have agreed to. And that, it really is quite difficult to square that with any, what happened, which is a decision to undermine that approach, to square it with any good faith obligation. Now, it may be that one has to zoom out a little bit and look at it in broader terms and include Mr. Costa's failure to go back to the board and consult if he did genuinely consider that a better course of action would be to defer. And of course, that is what he should have done. But overall, we say in the round, this was a correct finding of breach of duty by the Court of Appeal, based upon, at least founded upon, the idea that the company had determined what the success of the company should be. Yeah. And Mr. Costa's conduct in the round, and I will include his misleading the board, his failure to go back to the board to seek a revised approach, must be in breach of the Section 172.
Well, my problem is I can see easily why it was a breach of his duty, bearing in mind he was entrusted by his fellow directors, and for that matter by the shareholders, with achieving the objective set out in the shareholders' agreement. And it's difficult to imagine any more plain breach of that trust than to go and do something completely different and conceal it from the people who'd entrusted him with that responsibility. My problem is why it's either necessary or appropriate to try and cram that into Section 172. That seems to be what's done, and we're stuck with it.
Well, my Lord, that is, if I may say so, a conventional approach to an unfair prejudice petition. One does look for breaches of the director's duties.
Sure, but there was another breach, which was that he was entrusted with he was given sole responsibility by the board with this task, so the judge finds, and I assume that was your pleaded case. Well, that would be a breach of duty regardless of 172.
He was certainly leading the process. He was given principal responsibility for it.
Well, the judge said he was entrusted with it.
Yes.
That's his language.
Yes.
And I'm assuming that was the pleaded case.
Certainly to that effect, my Lord, yes. But so we have this other breach of fiduciary duty, or other respect in which the duty was breached, which we say is actually not part of what they sought to obtain permission to appeal on at all.
Yes.
The other way in which we say there was a breach, of course, is the more direct going to mislead the board. And we see the analysis of that in the judgment of paragraphs 103 to 112. That's starting on page 116 of the bundle. And what we see in paragraphs 107 is reference to compound photonics and the idea that the core meaning of a requirement of good faith is that it requires honesty. Then that must be especially so in relation to 172 because it's a codification of a fiduciary duty. There's reference to Lord Justice Millett and Mothew. And then we get to the fact that, at least nowadays, everyone's very clear that a duty of honesty is to be judged on the Ivy and Genting approach with an objective appraisal. And that was probably well established before Brunei Airways, but certainly it's been made absolutely clear following Ivy and Genting. And we see that at paragraph 111, and then the discussion starts at paragraph 120, and we see, it's page 121, And we see the Court of Appeal saying that it was the judge's approach deprived the phrase in good faith of all content and meaning. In a sense, what they were saying was good faith might as well simply be sincerely or genuinely or really, really. It doesn't add anything of substance. And then there's reference to Lord Green's statement in Smith and Fawcett, and this is the point my Lord Burrows made earlier on, that properly construed, that statement is referring to the exercise of the discretion, i.e. what the directors actually do. It can't be confined just to the quality of the thinking. And then in paragraph 123, well, rather, paragraph 122, we have the Court of Appeal's statement, effectively, of what 172 means. And just to make one point here, it's important to note that it's to act in good faith towards the company. Now, my learned friend makes great play of the Law Commission debates about whether there should be a duty of honesty. But what the Law Commission and the CLR were considering, maybe the CLR more, was a freestanding duty of honesty to everybody. And one can readily see that if you imposed a duty of honesty in a freestanding way on a director, that could well rub up against the more specific duties that a director owes to the company itself to act to promote its success.
Can I just check? You say the director must act in good faith towards the company under Section 172. Is that because the Section 172 duty is a duty owed to the company?
Yes.
Is that why you say that?
Yes, and I assume that's why the Court of Appeal also adopted that formulation. And I'm making the point that that is to be contrasted with what the Law Commission and the CLR were contemplating, which was a freestanding duty to act honestly. And one can see that that would be problematic, potentially.
To sort of contractual counterparties.
Quite. Yes. So it's unsurprising in my submission that that proposal was not taken forward. And equally, the formulation here makes perfect sense. You act honestly towards your principal, your company. Now...
Yeah, sorry, just on that, just before I forget, I think that was, in effect, the point being made at CLR 3, paragraph 3.13, page 2058. The particular example they give is sometimes a director may have to procure the company to breach a contract. Yeah. Is it going to be, is that owed to which the company's in with another person? Is that going to be said to be dishonest, or that's an area of problem?
My Lord, one can well see that would cause problems if suddenly you're going to impose an objective test as to whether or not the director in that situation has behaved in an honest or above-board fashion.
Yes.
And so that was rejected.
So you saying that they were not talking there about whether there was an objective element in the duty towards the company?
They were not talking about that. My learned friend, Mr. Rivet, will address you in more detail on precisely what they were dealing with. But we certainly reject the proposition that anything said in the Law Commission reports or the CLR is inconsistent with our case, which is that the duty under 172 includes a duty to act in good faith towards the company, and that obligation includes the requirement to be honest towards the company, and honesty is to be judged objectively. There's nothing in the reports, we say, that can really be taken by this court, of all places, to actually be authoritative. So then we got to relief, and we see in paragraph 133, the court did consider that the finding of breach of fiduciary duty was very important when it came to relief, because it was on that basis that it was decided that it was appropriate to order an unconditional buyout order, rather than rather complicated set of counterfactuals and conditions that the judge had imposed. Because if you're in an unfair prejudice situation, you can't, it's unfair for you to be saddled with a director who's shown himself prepared to breach his fiduciary duties.
I suppose I'm looking at paragraph 133 on page 123. When you see why the Court of Appeal thought it mattered, it wasn't necessarily because it fell within section 172, as I understand it. It's because they thought that if the director is shown as having behaved in that way towards the shareholders and the board, you just couldn't make a conditional buyout order. You had to achieve a clean break.
My lord, yes. That's right. That's the substance of it. Obviously, the arguments have been framed around 172.
Well, that's almost like a sort of mantra. Everybody's been talking about 172. When you actually look at their reasons for saying why it makes a difference.
This person can't be trusted. Why should...
Well, this person's behaved in a underhand way, if you like, towards his board and his fellow shareholders.
Yes.
The minority shareholders.
Yes.
Yes,
So
well,
this,
particularly minority, yes.
so it's not right that the successful petitioner might nonetheless not get a buyout
Yeah.
due to some set of counterfactuals. Now, my lord, just very briefly, my lady as well, on the grounds of appeal, just so you have them. It's page 521. And my learned friend took you to these. It's very clear beyond any reasonable argument, I would suggest, that the only appeal was against the first, the finding of breach based upon misleading the board, and the point of principle as to whether or not there should be an objective test applied in that regard. And then the second ground, it's really a follow-on. It's a consequential ground, is that if they they succeed here in overturning that finding of breach of fiduciary duty, it must follow that the conditional order should be restored, because the
Right.
court...
But are we now not in a position where we have factual findings, we can analyse the law for ourselves, that doesn't the second ground, if expanded in the way that Mr. Crowe wants to expand it, simply give rise to arguments of law in the light of findings of fact that have been made? So
Well, Lord, I'm not going to waste time seeking to persuade you not to deal
right.
with it.
So you're content for us to give permission for Mr. Crowe to run
On this, I'm in your hands. It's a matter for my lady, my lord.
Well, we're in your hands as to what submission you want to make.
Well, my submission is they don't have permission, but if you are prepared to deal with it, I say, so be it. I'm happy to deal with it.
I mean, you're not complaining that you haven't had an opportunity to respond to it.
No, and we have a good response, which is that, and I'll take you to the point, which is that if one looks at the way in which they deal with it in their written case, we go to their written case, paragraph 55. They basically don't deal with it. So paragraph 55 is page 49 of their written case. And the short point is that they deal with this aspect of the breach as purely based on the notion that the Court of Appeal found that it had to be a breach of fiduciary duty to cause the company to breach a contract. In other words, any contract. So we see that in paragraph 55.2, where it said, by holding Mr. Costa in breach of section 172 purely as a result of him causing the company to act in breach of contract, the Court of Appeal ignored the applicable statutory test. Well, with respect, that's not what the Court of Appeal did. They did not hold him in breach purely for breaching a contract. They held him in breach because that contract identified the success of the company, because it's an unusual contract that bound the company and all of the members. That is why it's a breach. And that is simply not addressed in these very short paragraphs in which they try to bring this appeal for which they don't have permission. And my learned friend did not address it in his oral submissions either. So that's what I say about that part of the case. The other respect in which they seek to expand their appeal beyond where they had permission. I'm conscious that my learned friend only had 2 minutes to develop this case. But what they seek to say is that if they're wrong on the point of principle around the construction of 172, in other words, if it is the case that the court does apply an objective test in respect of good faith and dishonesty, they say, well, the Court of Appeal was wrong to make a finding of dishonesty. Now, that is a much more problematic thing for them to try and run in this place without permission. Because what we see, and we see it in their written case, is it's a form of island hopping. They hop around the judgment, which is a lengthy judgment and has a disparate range of findings or half findings, seeking to identify bits and pieces that might be taken to support the case that Mr. Costa was not objectively dishonest. Now, we too have lots of bits and pieces from the judgment that we would rely upon, and there's a wealth of material that was at trial that could also be relied upon. I've given you a taste of the findings and as regards Mr. Costa's behaviour, and what we say is it's simply inappropriate for them to seek to reopen the substantive question of dishonesty at this stage. Now, insofar as it's suggested that it was wrong in principle for the Court of Appeal to have made its own finding of dishonesty, I make 2 points. Firstly, I refer to what I said about the judge's statements about dishonesty. In a sense, the judge did not himself make any clear findings to the effect that the parties were not dishonest in the context of 172. He made some general observations that in the round, he wasn't prepared to characterise their conduct as dishonest. As I said, there wasn't much analysis and fundamentally no attempt to square that with his subsequent findings of misleading the board, and it is very difficult to square the two. So, as I said, those findings in themselves have to be treated with caution. And secondly, it's not as if the Court of Appeal itself sought to reappraise the underlying material at trial. This was not the case of the Court of Appeal saying it knew better about how to analyse the evidence and the transcripts, documents, better than the trial judge. To the contrary, all the Court of Appeal did was take the findings of fact made by the judge and then apply what it said was the correct objective test. So we say that was a perfectly proper approach in any event.
But you do accept that the judge found that Mr. Costa genuinely really believed in good faith that what he was doing was in the best interest of the company.
He did make that finding, yes.
And you also, I think, accept that there was no challenge before the Court of Appeal that was a perverse finding or...
My lady, I don't accept that. We certainly did challenge that. We said that the conduct was in breach of 172. That was our appeal.
Yes, but not on the basis that you asked them to find that subjectively he didn't really think that it was in the best interest.
No, we didn't seek to overturn, as it were, the finding as to his state of mind.
No.
Well, whether you did or you didn't, the Court of Appeal directly accepted it because they set it out to paragraph 113. That's the platform. That's the factual platform for their analysis.
And what happened in the Court of Appeal was our approach was in fairness and candidly, more along the lines of the breach of duty that I was discussing with Lord Sells and Lord Briggs in particular about the success of the company, how his conduct could possibly be squared with that, than the more, if you like, principled or sweeping position, which is that simply dishonest conduct must be in breach. That emerged in the course of the hearing, but we entirely endorse it, obviously, and it's consistent with our basic case, which is that the conduct must have been in breach of 172.
Yes. Might that be a convenient?
My Lord, thank you.
Very good. We'll adjourn now and resume at 2 o'clock. Yes, Mr. Davis.
Thank you, my lord. Before the break, I was principally focusing on the first instance judgment and the Court of Appeal judgment, and with some, it's fair to say, forays into the more general arguments. So forgive me if we end up going over some of those arguments again, because I'm now going to move on to the arguments on the construction of Section 172, specifically around the meaning and effect of the words good faith. Now, we fully endorse the reasoning and decision of the Court of Appeal that the duty of a director under Section 172 includes the requirement that a director must act in good faith towards the company, and that acting in good faith includes the requirement to act honestly. We also respectfully agree with the view that honesty for this purpose must be assessed objectively. It's not open to a person to set their own standards of honesty. My learned friend, I think, said we haven't found any case that illustrates the court applying an objective test in this respect. But I think we have. As long ago as 1878, Lord Jessel, in the case of National Funds Assurance Company, was dealing with a defence by a director that they'd acted bona fide. And Lord Jessel remarked, "I cannot allow someone to come forward and say, I did not know I was doing wrong when I put my hand into my neighbour's pocket and took so much money out and put it into my own."
What's the bundle reference to that, please?
That's tab 81, page 4997, and the comments, remarks are at 5007. And Lord Jessel said the court would not dive into the recesses of the person's mind in such a case. Now, of course, we have the more recent decision of Ivy and Genting, as well as other decisions which entirely support the proposition that honesty is to be assessed objectively. And, of course, those are matters that the court should be taking into account in interpreting Section 172, pursuant to the guidance given in 170 sub 4 of the Companies Act. Now, before turning to a more detailed analysis of the formulation of 172, I want to make a couple of more general observations. And the first of those is this. Section 172 is part of a suite of duties that were codified under the Companies Act 2006. Those duties include duties concerned with the purpose for which powers are exercised, which is obviously Section 171, and duties concerned with conflicts of interests and secret profits, which we find in Sections 175 and 177. But Section 172 is the duty of broadest application because it applies in respect of everything that a director does in that capacity. It applies to anything that a director does in the performance of his functions as a director. In effect, it lays down the basic rule for how directors should conduct themselves. My learned friend's case is that this basic rule permits directors to act dishonestly towards their principal, the company. With respect, that cannot be right. The second general point concerns the...
Well, I think his submission ultimately went further. It requires him to act dishonestly.
My Lord, I think that's right.
Yes, all right.
The second general point concerns the subjective and objective terminology that one sees in these kinds of cases. And those words are used in different ways, and it's important to understand the ways the words are being used. My learned friend's central case, indeed his mantra, is that the duty under Section 172 is subjective. And it's certainly true that the duty under Section 172 is generally described as subjective. I should say, for what it's worth, in our skeleton below, we didn't describe it as purely subjective, as my learned friend suggested, but we did describe it as subjective, and that is a common tag applied to the duty. But it's important to understand the particular way in which this term is being used. The way it's being used is to capture the point that it is a matter for the director themselves to decide what is in the best interests of the company. In other words,
Sometimes called the business management rule.
I think it is, my lord.
Yes.
Yes. And it reflects a general reluctance of the courts to intervene in matters of that kind. So in other words, compliance with the duty does not depend upon doing what a hypothetical reasonable person would consider would be most likely to promote the success of the company. It's a matter for the director. Now, as an aside, I would not want this to be taken to mean that we accept that a director has completely free rein to decide what is best for the company. After all, in this case, we say Mr. Costa breached his duty because he acted in a way that was incompatible with what the company and the members had agreed the company should be doing. We've had that debate. I'm not seeking to reopen it, but we do say that even this subjective aspect of the duty has some limits, albeit possibly only in unusual cases. But we entirely accept that, generally speaking, the director is given a very broad discretion in relation to the issue of what is going to be best for promoting the success of the company. Hence the use of the court's use of the term subjective in this context. So routinely in the cases, the question is whether or not the director did in fact act in what he considered to be the best interests of the company. And provided that the court is satisfied on the facts that the director did so act, one sees the court time and time again saying that the test is subjective and it will not impose its own view. But it's one thing to say the court will not override the director's view as to what is in the best interest of the company, and quite another to say that a director's freedom of action is completely unregulated, provided that they believe they are acting in the company's best interests. And we don't think, and we suggest this is the case, that the use of the terminology in the cases of subjective cannot be taken as far as my learned friend suggests. And we submit that a director's freedom of action is also subject to the requirement to act in good faith towards the company. And in a sense, that is to be seen as a different aspect of the test, of the duty, separate from the requirement to act in what you consider is in the best interests of the company. And that's the very point that the Court of Appeal made. It's paragraph 106, we don't need to go to it, but they referred to the well-known dicta of Mr. Justice Jonathan Parker in Regent Crest, to the effect that the duty is subjective, and the Court of Appeal say in terms that those dicta are primarily designed to explain that in a commercial company, it's the directors, not the court, who decide what the best commercial approach for the company is. In other words, the subjective terminology is restricted to that aspect of the duty, an extremely important aspect of the duty, of course, but it is directed at that part of it. And so we say my learned friend's reliance on these statements, the use of the term subjective, and does not answer the point that arises on this ground of appeal, which specifically concerns the meaning and effect of the words in good faith, the good faith aspect of the duty. Finally, on the question of the terminology subjective, objective, I would observe that even on the view of the world that I've presented, where there is an objective dimension to the test, on one view it's still a subjective test. We're still looking at the state of knowledge of the person, the director. So in that sense, it still could properly be described as still a subjective duty, notwithstanding that we say there is an objective component that applies in respect to the good faith aspect. And the point that a dishonest state of mind is a subjective mental state was made by Lord Hoffman in the Barlow, Clowes and Eurotrust case, and the reference for that is 3575. So one could still
I have to say, I begin to lose track when one starts to say that the test of dishonesty, as now understood, is subjective. Because I think there's been a huge debate, and I think it's going to get us into terminological difficulty to pretend that it's subjective. It is an objective test, albeit based on the knowledge of the particular individual in place. That is what Ivy Genting said. The Barlow-Clowes decision was effectively departed from.
My Lord, I don't want to get into a debate about...
I've got that wrong. Sorry, it wasn't the Barlow-Klaus
Twin
case. It was
Sector.
the Twin Sector case, wasn't it? It was departed from in Barlow-Klaus. But speaking for myself, I would not find it helpful to regard the present test of dishonesty in Ivy Genting as classified as subjective.
And my Lord, I'm not seeking to do so. I heartily endorse your Lordship's desire not to get into a debate about terminology. In a sense, that's the point of my submission, which is a great deal of my learned friend's case rests on the use of this term subjective. And one has to analyse the purpose for which that term is being used. And it's always being used for a very specific purpose, which is to describe the part of the duty that's concerned strictly with the director's own decision-making in respect to the best interests of the company. So to summarise our position on the approach that should be taken in applying the duty under Section 172, what we say is as follows. In considering whether any act of a director was in accordance with the duty under Section 172, it is necessary to inquire into the director's own state of knowledge. One then seeks to establish, as a matter of fact, whether the director acted in the way that they considered was most likely to promote the success of the company as a whole. And that question is generally treated as something that is properly to be decided by the director, not the court. However, there is another aspect of the duty, which I've described as the good faith aspect, and it's necessary to give meaning and effect to that part of the duty as well. And the way that is done is to require a director to act towards the company in good faith. What does that mean? Well, as per the Court of Appeal, its core meaning is that the director must act towards the company in a way that is honest and not dishonest. One might put the overall effect like this. A director has a broad discretion to act in the way that they think is most likely to promote the success of the company, but that is subject to a limit, a guardrail, if you like, that whatever their views, they cannot act towards the company in a way that is dishonest. Now, there are various illustrations of this kind of approach in the cases, limits on the director's freedom of action. I don't think I've got time to take you to the case.
But they have to act honestly. At that point, you do bring in the ordinary decent people's view of their conduct.
My lady, yes. At that point, on that aspect of the test, there is an objective test as to whether they behaved dishonestly. And there are illustrations in the case law where the courts have imposed limits, effectively, on the director's freedom of action and have approached this in an objective way. And I refer to the case of Item Software and Fasihi. The reference is 4416. And so I won't take you to it, but just in brief, there are similarities to our case, because in that case, the director had been secretly pursuing his own plan, which was directly inconsistent with the plan being pursued by the company. And the complaint was based upon the fact the director had not disclosed what he was up to the board. Now, again, we say that's rather similar to our case. And if the director in that case was guilty of a breach of duty, it should be a fortiori where the director has actively misled the board. And the Court of Appeal upheld the finding of breach of duty. But the particular point that I dwell upon is paragraph 44 of the judgment.
And was it a breach of 172?
Yes.
Oh, it was before 172, but it was...
It was the duty to act in...
It's before Section 172. It's a
Yes.
2004
So duty to act in the best
Yeah.
interests of the in good faith in the best
Yeah.
interests of the company. Yes.
Sorry, which paragraph were you going to?
Paragraph 44.
Page.
It's 4429.
Thank you.
Thank you, my lady. And what we have there is Lady Justice Arden, as she then was, mean, the case is principally known for her dicta that you can't treat the duty to disclose your wrongdoing as a freestanding duty. It falls under the general umbrella of the duty to act in good faith in the best interests of the company. But nonetheless, failing to disclose wrongdoing would be a breach of that duty. But then we see at the end of paragraph 44, what she says is as follows: furthermore, on the facts of this case, there is no basis on which Mr. Fasihi could reasonably have come to the conclusion that it was not in the interests of Item to know of his breach of duty. In my judgment, he could not fulfil his duty of loyalty in this case except by telling Item about his setting up of RAMS and his plan to acquire the isograph contract for himself. So I'm really just focusing on those words, reasonably have come to the conclusion. That demonstrably is an objective analysis being applied in this case. And we make a similar point in respect of the dicta of Lord Justice North in the Onilda...
Sorry, just on that paragraph 44, seems to me potentially relevant earlier on in the paragraph where they just are and is talking about the general duty of loyalty. She quotes from Justice Cardoso, he refuses to confine in the bounds of classified transactions. It's precept of a loyalty that is undivided and unselfish. In other words, loyalty, a duty of loyalty operates at quite a high level of abstraction, but then comes down and has various aspects in its application to particular facts.
My Lord, yes, and we see that possibly even more clearly set out by Lord Justice Millett in the Mothew case, which I'll take you to shortly.
Yes.
So the other case that we rely upon for a similar point is the Onil de Felby case, which is at page 4697, and specifically the dicta of Lord Justice North, which we also say indicates an objective view. What he says is someone could not hold the view in good faith. So in effect, the court has imposed limits. These are two decisions of the Court of Appeal.
And sorry, you've given us the page reference for the start of the case. Where is the page reference for the statement you rely on?
Is 4702, my Lord.
Thank you very
And
much.
it's the third paragraph of Lord Justice North's judgment.
Thank you.
The one starting the principle is. Sorry. No,
Yes,
I'm not sure.
Thank you.
Oh, yes.
So I've made the general point that Section 172 is what I would describe as the basic duty of a director. It applies to all of their conduct. I've discussed the subjective and objective terminology, and I've at least referred to two Court of Appeal authorities where the approach taken by the court can properly be described as applying an objective test, an objective limit to the director's freedom of action. In terms of other common law, we've seen Smith and Fawcett. We've seen that the Court of Appeal in this case referred to that case and took from it that actually the good faith or bona fide terminology was directed at the actions of the company, of the board. I want to now take you to Bristol and Western Moffat.
It might be said that Smith and Fawcett is a powerful vindication or expression of what my Lord referred to as the business management rule, because that's looking at a case where the directors are acting together and they're making a business judgment.
Yes, for which they had some apparent justification, but anyway, that was sufficient for the court to leave them to it, so to speak.
Yes.
Can I just ask you, when you have used these two cases from the Court of Appeal, you've pointed to an objective element. Is it essential for your argument that that objective element is regarded as an aspect of dishonesty? Because it might be said, might it not, that whether it is or isn't within the dishonesty test, it is imposing at least some sort of objective requirement over and above the subjectivity.
So, my Lord, test obviously is in terms of good faith.
Yeah.
And so all we would need to show is that there was a failure to act in good faith. And what the O'Neill case and the item software case show is that the courts in those cases did not feel the need to develop any broader principle of dishonesty. They were satisfied that objectively the conduct could not be described as in good faith.
I mean, it might be said that actually to use the concept of good faith is necessarily to impose some sort of objective criterion, because you're using that to judge whether the subjectively inspired behaviour of the individual meets that standard.
My Lord, yes. Similar reasoning, of course, leads one to apply an objective test to the word honesty. But likewise, one can see...
Except honesty has this sort of encrustation that's grown up in the criminal context over how it's to be applied. I was making a more general point.
Well, my Lord, certainly I would agree that as a matter of language, if nothing else, if one is to courts to approach whether something is in good faith, it seems perfectly apt to provide at least objective limits to what could conceivably be in good faith. And we do see that in those two cases. But what happened in the Court of Appeal in this case is that the Court of Appeal did decide to adopt, or at least introduce, some further thinking as to how the good faith test might operate. And given the case law to the effect that a duty of good faith, at least at its core, includes honesty, in my submission, that was the correct approach, because once you are in the realms of honesty, we are in the realms of Ivy and Genting, and a very established approach as regards an objective test. But in a sense, it wasn't, I would suggest it perhaps wasn't necessary, strictly, for that analysis to be introduced. The court could easily have just said, objectively, we consider that the conduct of Mr. Costa here could not have been in good faith, and left it at that. Now, I was going to take you to Bristol and West and Mothewell, which is D2. I beg your pardon, page 3676.
3670.
3676, my lord.
Thank you.
And this will be a judgment that's well known to you, so I won't dwell upon the facts. It was a solicitor acting for a purchaser of a property and the lender. And the classic statement as regards the nature of fiduciary relationship is starts on page 3693. And it's right at the top of the page, A, 4 lines down. A fiduciary is someone who has undertaken to act for or on behalf of another in a particular matter in circumstances which give rise to a relationship of trust and confidence. The distinguishing obligation of a fiduciary is the obligation of loyalty. The principal is entitled to the single-minded loyalty of his fiduciary. This core liability has several facets. A fiduciary must act in good faith, in the sense that that is the critical point as far as we're concerned, and it's entirely supportive of our case that the duty under 172 has more than one aspect, and one of those aspects is the good faith aspect. And here we see Lord Justice Millett saying there is a duty to act in good faith. And he goes on to talk about not making a profit, not placing himself into conflict, and may not act for his own benefit. Now, that is seen as a separate facet of the duty, whereas on my learned friends analysis, it's the beginning and end of it. It's the entire and only purpose of the terms in good faith in this provision. But quite clearly we have this very authoritative statement on what the obligation of loyalty includes, and it includes a duty to act in good faith. Of course, there's the case of Regent Crest. I haven't got time to go to it, but it's well known as the famous statement that the duty is subjective, and I've explained our case as to how that should be approached, that terminology. So what we say is that the common law clearly establishes the basis fiduciary duty of a director includes a duty to act bona fide, or in modern language, in good faith, towards the company. And that is a substantive requirement. The words are not mere gloss. They're not just there to provide some kind of emphasis. Of course, quite often judges do provide emphasis. They say genuinely believed, or in this case, the judge said sincerely believed. But those don't actually add anything of substance. And likewise, we say the words good faith cannot be interpreted merely as empty words or emphasis. They should be given substantive effect. One other case I should refer you to because it's relevant on the facts.
Can I just pursue that towards the company point? I mean, you get it presumably from section 170 sub 1, which says all these duties are duties owed to the company, where the question is whether you, the way you behave towards your fellow members of the board, is the board to be sort of treated as the emanation of the company for that purpose?
My Lord, I think that's how I would see it. That is the organ of the company that the director is reporting to, essentially.
Even though he's part of the organ, yes.
Well, in a sense, he's disabling the organ, either by not telling them the truth or misleading them.
Yes.
So and the case I want to take, mostly because it's helpful on the objective test of dishonesty in our particular case, is Royal Brunei Airways and TAN, and that's at page 5368.
Sorry, 5638, did you say?
5368. That's the start of the
68, yes.
And obviously this case principally concerns the law relating to dishonest assistance. But Lord Nichols makes some remarks about dishonesty more generally, which have particular resonance in relation to the facts of the present case. So if you'd be good enough to go to page 5379. So you see a heading there, dishonesty. And what we have there is Lord Nichols really making the point that dishonesty is judged by an objective standard, but albeit at the risk of upsetting Lord Burrows, it is described as having a strong subjective element. But nonetheless, he describes the test broadly of dishonesty, but then more particularly, he talks about a particular situation at the bottom of the page. However, in the situations now under consideration, the position is not always so straightforward. This can best be illustrated by considering one particular area, the taking of risks. And at letter H, he says, well, taking a risk is not necessarily dishonest. Of course, it might be your role to take a risk. But at the top of the following page, he says as follows: this type of risk is to be sharply distinguished from the case where a trustee, with or without the benefit of advice, is aware that a particular investment or application of trust property is outside his powers, but nevertheless he decides to proceed in the belief or hope that this will be beneficial to the beneficiaries, or at least not prejudicial to them. He takes a risk that a clearly unauthorised transaction will not cause loss. A risk of this nature is for the account of those who take it. If the risk materialises and causes loss, those who knowingly took the risk will be accountable accordingly. This is the type of risk being addressed by Mr. Justice Peter Gibson in the Barden case, when he accepted that fraud includes taking a risk to the prejudice of another's rights, which risk is known to be one which there is no right to take. The conduct of Mr. Costa here falls exactly within that type of risk-taking, described here as a fraud. Now, moving on to...
But it may be said that actually that's not the correct analogy with this case. The correct analogy is this case would be if the risk is one which is within the trustee's powers, but the beneficiaries have collectively told the trustee, we don't want you to take that risk. But the trustee still thinks it would benefit the fund if that risk was taken.
In a sense, I mean, here there is the additional element of the agreement, which...
Yes, but putting aside the agreement at the moment, would...
Well, trustees are always being told by their beneficiaries to do or not to do things without being bound by that instruction.
I mean, here,
unless they're all the beneficiaries capable of binding a full age and sound mind and capable of binding the trust.
I mean, really, this resonates with the language in the judgment of taking a gamble. The judge describes it explicitly as Costa gambling.
I mean, I think strictly on my latest example, it's inherent in the trust relationship. It's the trustees that decide what to do with the property. So if they think it's right to take the gamble,
They can do it.
They can do it. They wouldn't be bound by the beneficiaries to whom they owe duties of loyalty, saying, well, please don't do it. Because the duty of loyalty is to apply their mind and their judgment, which is properly assigned to them as their own.
That's why there's a trust there in the first.
Well, I won't push the analogy too far. It's a dishonest assistance case which has comments about taking risks and how objectively that might be seen as dishonest.
Yes, I mean, the Brunei context is dishonest assistance, isn't
Yes.
it? Yes.
But you do have statements that taking risks with other people's property is seen as dishonest. Now, here you have to remember that Mr. Loy, for example, Mr. Flamini, who were directors, had explicitly said they wanted a sale. They expected the sale to be progressing in accordance with the terms of Clause 6.2. And Mr. Costa flouted that agreement and misled them and risked their property in the sense of their interest in the company by their shareholders. So the analogy may not be exact, but I suggest it's a helpful case in any event. Moving on to the terms of Section 172 itself. Just for your reference again, the section is at page 548. And as you're all aware, it's the successor duty to the common law duty of a director to act in good faith in what they consider to be the best interests of the company. The language has changed in certain respects, notably the best interests of the company has been replaced with promoting the success of the company for the benefit of the members of the whole. And we also see the addition of the new requirement to take account of various factors, albeit it should be noted that that list is not said to be exclusive. But we're not directly concerned with that aspect of duty. What we're concerned with, obviously, is the meaning and effect of the words in good faith. And the starting point, as a matter of statutory construction, I would suggest, is the court should be seeking to give some substantive effect to those words. That's just a basic principle of construction, that one should seek to give effect to the statutory words. And also, as I've sought to explain, the authorities show that as a matter of common law, the need to act in good faith towards the company was a substantive component of the basic fiduciary duty of a director. So that reinforces the importance that the court should be striving to give those words some substantive effect.
Well, just on that, it seems to me potentially relevant to look at section 170, subsection 4 on page 542, because there's a statutory direction that the general duties, which includes section 172, shall be interpreted and applied in the same way as common law rules or equitable principles. And regard shall be had to the corresponding common law rules and equitable principles in interpreting and implying the general duties. Well, and what one does sometimes find in legislation, parliamentary guides to how one should approach the interpretive exercise, and we're given that here.
Very explicitly. And
which points one back to the rather free-flowing old form of the common law duties, which have many aspects. And it might be said that by section 170, subsection 4, Parliament is saying you have to find homes for the operation of those principles within the general duties that have now been specified in the statutory form.
I entirely agree, Mark.
Can you just help me? Subsection 4, it sort of breaks down into two parts, split by a comma in the middle of the second line. I'm struggling to understand what the second half adds to the first half.
I would suggest the second half
Or was
is...
it just two different draftsmen who couldn't agree which view? So they
Which is the better way to put it, so we cover all bases.
I would suggest the second half is certainly easier to understand, because it just tells you you've got to look
Yes.
at common law.
yes,
You have to take that into account, and to my Lord Sales's point, unless there's a good reason not to, you should be expecting to find
yes.
homes for the principal facets of the duty in the modern formulation. As regards the first part of the sentence, that might more go to the process that the court has to adopt in interpreting and applying the law. It may be that there's a degree of flexibility that the law evolves. The common law is not set in stone, and so the court can have regard to developments in analogous areas in respect of the similar duties in assisting it and interpreting these codified duties.
Maybe, but one might have thought you were getting that,
From the second part.
well, or from the first part.
I mean, I don't want to take time on over it. I've just been puzzling for some time why it's...
It certainly means...
This is a good case because the meaning of dishonesty changed in 2018.
Yeah, certainly.
So that may...
So it's an always speaking type.
Yes, so these duties not set in stone at the point in time when they were codified. If the law relevantly moves on, the court can take account of it. So I would respectfully adopt that analysis, my lady, in respect to the Ivy and Genting. And what we say, obviously, is that in keeping with the decision of the Court of Appeal, the way to give these words substantive effect is to construe them as requiring a director to act in good faith towards the company. So one considers the actual conduct in question and the state of knowledge of the director, and then one asks whether the director was acting in good faith in relation to that conduct.
So is this right? You say, reading the first line of section 1721, one would say, a director of a company must act in the way that he considers, acting in good faith towards the company would be most likely to promote. Yes. Reading it long.
That would work for me, my lord. Likewise, the formulation of the Court of Appeal, I think, does the same as your lordship's formulation.
Just remind me what their formulation was.
Paragraph 122. Yes, paragraph 122, page 121 of the key document.
I'm not sure that's very significantly different from what I was putting. I mean, they haven't tried to read the words into the provision, but it seems to, well, at the moment, it seems to me to come to pretty
My
much.
lord, yes, that we entirely endorse that formulation, and respectfully, your lordship's formulation as well.
So you say it doesn't matter whether the words in good faith qualify the directors considering or the directors acting?
Well, we do say that they certainly cannot be interpreted as solely qualifying the word considers, because that renders them devoid of any substantive effect. I'll come on to explain that.
But you're principally seeing them as qualifying the word act.
Yes.
And when it says a director of a company, we can also read in, can't we, that we are talking about somebody who is a fiduciary.
Yes.
Because directors of companies are always fiduciaries.
Absolutely, my lord.
And there's an awful lot of common law and equitable principle about what that involves.
And doing the best I can, the Bristol and West and Mothew
Yes.
case is a good place to
One of many, but yes.
find that stated very clearly.
Yeah.
Now, in contrast, my learned friend argues that the words in good faith only operate on the consideration given by the director regarding their actions, rather than the actions themselves.
I'm so sorry, it's just because it was a thought inspired by what my lord just said. I think the point that my lord was making is reinforced, if I may say so, by section 178, subsection 2, civil consequences of breach of the general duties. That's page 566. It says the duties in those sections are accordingly enforceable in the same way as any other fiduciary duty owed by a company
I agree, my lord, and that is actually a point made in our written case.
Oh, I'm sorry. I probably
No,
mixed it
my
up
lord,
there, but-
absolutely, it's a good point, and we endorse it.
What section is that?
Paragraph-
1782.
Paragraph 27.
Page 566.
Yeah.
I mean, it's really just an elaboration from the statute on what my lord was putting to it.
My lord, yes, and it's paragraph 27 of our written case, which is page
Right.
65.
Drop
Why
from
is
my mind.
section 174 excluded?
Because it's not a fiduciary duty.
It's reasonable care, which isn't regarded as usually as a fiduciary duty. I think that's discussed by Lord Justice Millett in the Mothewell case, where he distinguishes between fiduciary duties and duties of care. Which
Yes, because there's both a claim for negligence and a claim for breach of trust in that case.
What's slightly odd about section 1782 is that it expressly assumes that the list which it's just referred to as the list, the duties in those sections, which is 171 to 177, are not a comprehensive list. Because it's assuming that there may be other fiduciary duties owed to a company by its directors. I think I'd always assumed it was intended to be a comprehensive list, but that doesn't suggest that Parliament or the draftsman necessarily agreed.
Why do you say that?
Well, because the duties in those sections, that's the whole of the 171 to 177 list,
Yes,
except for 174, are enforceable in the same way as any other fiduciary duty owed to a company by its directors.
Well, my learned junior suggests that might be directed at the creditor rule, which isn't specifically codified. But
No, it's not. You're quite right. That is an express exception. Yes.
that may
It's a
be
funny way of putting it. I mean, if that's all they meant, they would have said,
possibly
it's
keeping
a very
their
odd way to hang it.
might be
to.
keeping their options open.
Yeah.
But that
I mean, what I'm floating is the notion that the court doesn't lose sight of what it has traditionally regarded as attaching to a fiduciary relationship, merely because the principal aspects have been set out in this list.
My lord, I, as a general proposition, one should have regard to the general law on fiduciaries, for sure. But I respectfully would prefer my Lord Sale's approach of seeking to ensure, absent some very strong direction or reason to the contrary, that the duties as formulated, insofar as it's possible, do include what was generally understood to be the aspects of the fiduciary.
What about the duty to disclose your own misconduct?
Well, my lord, that would fall under 172 in accordance with item software. So Lady Justice Arden in that case was faced with the notion that there's a separate duty of a director to disclose one's own wrongdoing. And she rejected that idea and said it's not a separate duty, it's part of your general duty.
Yes.
Which is a duty of loyalty. I
Duty
think.
of loyalty, duty to act in good faith.
But hold on, item software is before the Act.
Just before, yes.
I wonder if a possible answer to the point raised by my lord is that section 1781 refers back to the old rules. Consequences of breach are the same as would apply if the corresponding common law rule or equitable principle applied. And we've already seen from section 170 that at the start of this particular sort of sections, it's saying, although we've got statutory duties, they're accommodating the content of what was in the old equitable and common law duties. And then as we come out of this group of sections, we're told, and the remedies will be essentially the same as used to be the case under those provisions. And one could still give content to the words any other fiduciary duty, because historically other fiduciary duties were owed. In other words, the scheme of the legislation seems to be there's a whole group of common law cases and principles relating to the fiduciary duty owed by directors to their company. We're seeking to have a statutory code that captures those, and section 178 possibly could be read as saying, and when we're looking at the consequences of breach of those, it's the same as if the corresponding common law rule or equitable principle applied, and one sees the word accordingly also in subsection 2, and they're therefore accordingly enforceable and so on. Anyway,
We may not need to go there, but
we probably don't need to go there, but it was just something that occurred to me.
My Lord, and ultimately it's clear that they didn't want to grapple with codifying the consequences of civil consequences of breaches of these duties. And this is an attempt just to at least make that much clear that the common law will apply in respect of the consequences.
Your essential formulation of 172 subsection 1 is it would have been much better formulated had in good faith come after must act.
I have to accept that, my Lord. And you can see plenty of the common law cases where that is how it is indeed formulated, including Smith and Fawcett. Now, my learned friend's argument is that the words in good faith only operate on the consideration, so it's purely an inquiry into the quality of the director's thinking. And I referred earlier on to paragraph 33.4 of their case. Might be worth just having that. It's on page 40 of the bundle. And it says, the obligation on the director to form his opinion in good faith captures the duty of loyalty. And then it goes on. It requires a director to form his opinion uninfluenced by considerations of self-interest. Now, we say there are a number of problems with this analysis. Firstly, in describing the duty only as an obligation to form an opinion, that departs from all of the common law to the effect that the director must act in good faith. Secondly, it's just not clear what forming an opinion in good faith really means. You either form an opinion or you don't form an opinion. Now, in paragraph 33.4, they try to explain what they mean by arguing that the purpose of the words in good faith is to require the director to form their opinion uninfluenced by considerations of self-interest. But that explanation is also inadequate for a number of reasons. In the first place, the concept of good faith would not naturally be understood to be confined to avoiding self-interest. It's an artificially restrictive interpretation of the words. One can imagine lots of different ways of acting otherwise than in good faith that don't necessarily entail being self-interested, notably simply lying to the board or acting in someone else's interest. Secondly, and this is a point I made earlier, it's noticeable that the way they put their argument is avoiding being influenced by self-interest, which is self-evidently a broader notion than actively seeking to prefer one's own interests over those of the company. Now, obviously, if it was put in those terms, preferring your interests, there would be a breach of 172 in any event, because you wouldn't be promoting the success of the company, you'd be promoting your own success. So, understandably, they can't adopt that harder-edged self-interest, and they have to adopt a broader formulation. But in so doing, they render it unworkable and effectively meaningless. Indeed, we suggest that the concept of not being influenced by self-interest is not even a necessary part of being in good faith, because one can reach a decision in a way that's both in good faith and also in one's self-interest. Perfectly possible for a director's interests to align strongly with those of the company. And in such a case, it would be unreal to stipulate that the director's opinion must be formed in a way that is uninfluenced by the director's personal interests. Apart from anything else, it's incredibly difficult to see how any such requirement would ever be policed. And what if it was found that the director had decided upon a course of action on the basis that it was both in the best interest of the company and in his own best interests? Would that be a breach? It's entirely unclear how this is supposed to work. Of course, it's a different matter if the interests are in conflict, but there are separate duties to deal with that. So we say that the attempt, the theory advanced by the other side to try and give content to these words is completely inadequate. What's going on here really is they're desperate to avoid an outcome where there's an objective appraisal of the good faith or honesty of Mr. Costa's actual conduct. So what they're trying to do is confine the operation of the concept of good faith to the quality of the director's thinking in relation to the part of the duties that is concerned with whether the director is acting to promote the success of the company, because that's the bit of the duty or the aspect that's conventionally seen as a subjective matter. So they can simply say, well, it's all subjective, therefore an objective test is inappropriate. But as I say, in the result, they deprive the words of any actual meaning. Ultimately, on Mr. Costa's approach, and this was a point taken in the Court of Appeal, was that the duty would work just as well if the words were not there at all. And what we say is that given the prominence of the concept of good faith in the common law, Section 172 has to be given substantive meaning and cannot be reduced to empty words. Ultimately, Mr. Costa's case is based on the proposition that the duty of loyalty, which is the touchstone of the fiduciary relationship, does not include an objective test of honesty. But there's no adequate basis for that assertion. It's established as a matter of common law that the duty of loyalty does include a duty to act in good faith. See Bristol and West against Mothew. It's established that a core requirement of good faith is honesty. See Compound Photonics. And it's also established that honesty is assessed objectively. See Ivy and Genting. Above all, it would be a very peculiar form of loyalty that permitted you to act dishonestly towards your principal. That is what my learned friend's case amounts to. The correct position, of course, is that being honest towards one's principal is an essential aspect of a fiduciary's obligation of loyalty. So, for these reasons, and the reasons set out in more detail in our written case, we say the Court's analysis of Section 172, the Court of Appeal's analysis of Section 172 should be upheld, and the attempt on the part of Mr. Costa to argue for a construction that would permit him to act dishonestly towards the company should be rejected. And it follows that, at least on the basis of the appeal for which Mr. Costa had permission, that appeal fails, and the finding that Mr. Costa breached 172 by misleading the board stands. And then it must also follow that the other ground of appeal for which permission was granted, which is seeking the reinstatement of the conditional buyout order, that must fail because the breach of fiduciary duty still stands. My Lords, my Lady, I'm now going to hand over to my junior to address you on the Commission, Company Law Steering Group.
Yes, thank you. Mr. River.
Thank you, my Lord. My learned friend relies on various reports to demonstrate that a deliberate decision was taken by Parliament not to introduce an express duty to act honestly. And that reliance on my submission is misplaced for two reasons. First, it involves a misuse of the relevant reports. And secondly, it involves a misreading of what those reports and documents actually say about the duty of honesty. And I'll develop each of those submissions in turn. Starting first with the relevance of the various reports. In order to assess their relevance, it's obviously important to be clear as to the nature of the court's task. And that task is to interpret a statutory provision, specifically Section 172 of the Companies Act. And helpfully, the statute tells us how to interpret Section 172. We've already looked at the relevant provisions, but they are Section 170, subsection 3, which states that the general duties are based on certain common law rules and equitable principles as they apply in relation to directors and have effect in place of those rules and principles as regards the duties owed to a company by a director. And then Section 170, subsection 4, which provides that the general duties shall be interpreted and applied in the same way as common law rules or equitable principles, and regard shall be had to the corresponding common law rules and equitable principles in interpreting and applying the general duties. So in order to interpret the duty under section 172, one needs to look no further than the corresponding common law rule or equitable principle which it replaced. Unless there be any doubt about that, the explanatory notes to the Act make the same point. The explanatory notes for section 172 are at page 579 of the bundle. You don't need to turn it up, but at paragraph 325, the opening paragraph says that this duty, namely the duty under section 172, codifies the current law and enshrines in statute what is commonly referred to as the principle of enlightened shareholder value. The source of the common law rules and equitable principles which section 172 replaced is self-evidently the case law on which those rules were developed. It is not, of course, the various reports and consultation documents upon which my learned friend relies. The question then is, well, what is the relevance of these reports? And as to that, please may I show you the decision of the House of Lords in Black, Clawson and Papia-Verka. It is at page 3581 of the bundle. This case involves the proper construction of section 8.1 of the Foreign Judgments Reciprocal Enforcement Act 1933. And one of the issues was the extent to which and the purposes for which the court could look at a pre-legislative report. And importantly, annexed to that report was a draft bill, the wording of which was almost identical with that of the Act as subsequently enacted. And now their lordships had slightly different views on this question, and their views are summarised at the bottom of page 3582 and the top of 3583 of the case report. And the views of the majority are summarised next to letter G on page 3582. These are the views of Lord Reid, Lord Wilberforce and Lord Diplock. And given the time, I'm proposing to take you just the judgment of Lord Diplock, which is in fact the judgment relied upon by my learned friend in his written case. And the relevant part of his judgment starts at page 3626, next to letter H towards the bottom of the page. However, in fact, I'd like to pick it up on the next page, page 3627, next to letter D. And Lord Diplock says this, says, I do not, however, understand that any of your lordships go so far as to suggest that a court is entitled to put a strained construction on the words of section 8 in order to give them the effect the committee thought that they had, if this would involve departing from their plain and natural meaning. It is for the court and no one else to decide what words in a statute mean. What the committee thought they meant is in itself irrelevant. Oral evidence by members of the committee as to their opinion of what the section meant would plainly be inadmissible. It does not become admissible by being reduced to writing. And then, having identified the purposes for which the committee's report could not be used, Lord Diplock went on to consider the purposes for which the reports could legitimately be used. And he says this, that what is suggested is that recourse may be had to the report as an aid to construction in order to ascertain first what the existing law was understood to be upon the subject matter of the Act, and secondly, what was the mischief for which Parliament intended to provide a remedy by the Act. Lord Diplock then went on to expand upon those two purposes, and in fact it is the passage immediately following the one I just read, which is relied upon by my learned friend at paragraph 22 of his written case. Now, of those two purposes, it is only the first which is relevant to the present appeal. The pre-legislative reports on which my learned friend relies can only be relevant in the present case insofar as they contain a summary of the existing law, as the commissioners and steering group understood it. My learned friend said it was common ground that those reports could be used to explain what the 2006 Act was to provide. That's not true, as we say at paragraphs 73 to 74 of our written case on page 78. It is purely for the purposes of understanding what the law was at the date on which the Acts were passed. And I say that because we don't, of course, need to look for any mischief. We know what Parliament's intention was. The Act tells us expressly it was to codify the existing law. It wasn't to bring about any change in the law. So if a director's duty of good faith requires them to act honestly towards their companies under the general law, section 172 must be interpreted to give effect to that requirement, irrespective of what the Law Commission or the steering group thought at the time of their reports. And that's important to understand because what my learned friend seeks to do is to look at the different ways in which the Law Commission and Steering Group considered formulating the statutory duties. And on the basis of that analysis, he seeks to draw inferences about what Parliament intended by the language which it used in section 172. That approach is wrong. Turning to the reports themselves...
That's because people in Parliament didn't necessarily know that the wording had gone through several rewrites, which may or may not have had some significance.
Well, exactly, my lady. And in fact, I'd say it's further than that, because what Parliament did do was then explain precisely how the duties should be interpreted through the provision at section 170.
So your central proposition is we can only use all this, but on the face of it looks very useful information for the purposes of looking at what the law was prior to the Act. Exactly, my Lord, in terms of their author's understanding of what the law was. If we turn to the reports themselves, it's quite useful to see what that understanding was. If it was all in the textbook, we'd have no problem looking at it, is that right? Well, no, my Lord. It'd be equivalent to looking at the Commission reports for the purposes of identifying what the summary law was, and that would be what the exercise you're doing when you look at the textbook. What you can't do is then go on to take the next step and say, well, let's look at the different ways in which they formulated the duty, and see if we can, from that, infer what the intention was using the language which they used. Now, the first report which my learned friend cites is the joint consultation paper from the Law Commission and the Scottish Law Commission in September 1998. It doesn't contain any clear discussion of the meaning of good faith under the existing law. That said, it does provide other examples of attempts to codify directors' duties, both in this jurisdiction and in other jurisdictions. And what's interesting is that each of those examples includes an obligation on the part of directors to act honestly. And we referred to the examples taken from Australia and Hong Kong in our paragraphs 76 to 77. My learned friend said that the approach taken in Australia actually supports his view because Australia has taken a different approach from the one ultimately adopted here. But that is not, in fact, what the Law Commission says. If I could ask you to turn to page 861 of the bundle.
Which of the Law Commission's reports is this?
This is the first Commission report relied upon by my learned friend, paper number 153. The paragraph 14.23, the Law Commissioners say this: it is clear that the duties with respect to corporate opportunities are not completely settled, and that it might be dangerous for that reason to convert them into statutory duties, since a case might arise which could not now be foreseen when they ought to have applied. In those circumstances, there is a case for codifying the duties which are not in doubt, such as the duty to act in what the director considers to be the company's best interests. This is the course that has been followed in Australia. As can be seen in Appendix 8, Section 232, sets out the duty of a director to act honestly, to exercise reasonable care and diligence, and not to make improper use of information or his position. So in fact, what the Law Commissioners were saying is that the approach taken in Australia reflects their understanding of the law. The report also quotes from two previous proposals in this jurisdiction to codify directors' duties. Those proposals were made in the Companies Bill 1973 and the Companies Bill 1978. Both proposals included a duty on the part of the directors to act honestly in the exercise of the powers and the discharge of the duties of his office. For your reference, the relevant quotations are at pages 853 to 4 of the main hearing bundle. Now, neither bill became law, they were abandoned as a result of general elections. However, it's notable that in quoting those bills, neither commission, neither the Law Commission nor the Scottish Law Commission, suggested that there was anything odd about the inclusion of a duty to act honestly. So one can reasonably infer that those bodies were satisfied that such a requirement formed part of the existing duty as a matter of common law. Now, the Law Commission's consultation paper was followed in February 1999 by a consultation document from the Company Law Review Steering Group. And this is the second document relied upon by my learned friend. In Chapter 5 of the consultation document, the steering group identified some key areas for consideration as part of their review and, importantly, sought to summarise the existing law. Chapter 5 starts on page 1070.
And sorry, which of these CLR reports was...
This is the first, what my learned friend referred to as CLR1.
Yeah, thank you.
And what was the year 1999?
Yes, February 1999. As I say, Chapter 5 starts on page 1070, but on page 1071, the steering group summarised the current legal framework. You can see that from the subtitle halfway down the page. And at paragraph 5.1.5, the steering group said this: the law on the formation and management of companies serves the interests of shareholders by conferring on them ultimate control of the undertaking. This operates broadly as follows, and they describe how it works. But picking it up at the bottom of the page, penultimate sentence, penultimate line, they say the directors are required to manage the business on their behalf, being obliged by fiduciary duties which require them to do so honestly in their best judgment for the benefit of the company. So that comes in a passage where they are reciting their understanding of the existing law. And the same point appears in paragraph 5.1.
Well, and then go on in the next sentence to deal separately with proper purposes and the duty of care and skill.
Yes, exactly. Then at paragraph 5.1.18, on page 1076, here, as you can see from the subtitle of the section, the context of this part of the report was a discussion about enlightened shareholder value. And this is the principle ultimately endorsed by the 2006 Act, that the ultimate objective of companies, which is to generate maximum value for shareholders, is also the best means of securing overall prosperity and welfare. At paragraph 5.1.17, the group say this: because the enlightened shareholder value approach is not dependent on any change in the ultimate objective of companies, that is, shareholder wealth maximisation, there would be no need under this approach to reform the fundamentals of directors' duties. They're just picking it up at 5.1.18 at the bottom of the page. The key company law provision is for the fiduciary duties of directors. These require them honestly, brackets, in good faith, to manage the undertaking for the benefit of the company. So not only do the steering group again refer to a requirement of honesty, but honesty is expressly equated with good faith. Now, thus far, there is nothing in the reports which is in any way inconsistent with what the Court of Appeal held in the present case, or anything which Mr. Davies has said. It's all consistent with the existence of a duty to act honestly. However, the position appears to be muddied by the subsequent report issued by the Law Commission and Scottish Law Commission in September 1999, and this is the report on which my learned friend places particular reliance. However, I suggest that the position is not actually that muddy once one understands the context and relevance of the comments on which my learned friend relies. The Law Commission's discussion of directors' duties begins in Part 4 on page 1300. And it introduces that section in paragraph 4.1 as follows. Parts 4 and 5 are concerned with the duties a director owes under the general law. There's then a footnote, footnote 1 at the bottom of the page. We describe these duties in parts 11 and 12 of the paper. That's the reference to the paper is a reference to their first Commission report, which I took you to before. Then returning to paragraph 4.1, it continues, we will not, however, be reviewing the content of these duties in any way, as this is a matter for the Company Law Review. We consider in this part the various ways in which a director's duties under general law could be made more accessible, certain and comprehensible. We examine the case for some kind of codification. And so the Law Commissions were not purporting to summarise the existing law on directors' duties or reviewing their content. They were simply considering the case for some kind of codification. And that, in my submission, is immediately a red flag. The commentary which follows is not relevant to the task at hand of interpreting section 172. Indeed, as you saw from his comments in Black Clawson, Lord Diplock would say that this commentary is actually inadmissible. And we can see this very clearly if we look at the paragraph on which my learned friend relies. Before we get there, just pick it up at paragraph 4.33 on page 1306. And what the commissioners say here is concepts such as good faith in the interests of the company and conflict of interest, which might be included in a partial codification, are relatively easily understood. Pausing there, if the concepts are relatively easily understood, then there is no need, of course, to resort to Parliament or non-parliamentary statements to interpret them. In fact, that point is underlined if we look at paragraph 4.35, which is on page 1307, and is the paragraph on which my learned friend relies. Because in that paragraph, what the Law Commissioners are doing is interpreting the meaning of words used in a draft statement of directors' duties. That's precisely the sort of material which Lord Diplock is admissible. But even if it were admissible, it's not clear what it tells us. Clearly, we accept that the Law Commissions do distinguish between good faith and honesty in this paragraph. However, they don't explain the basis for that view. Furthermore, having previously said that the concept of good faith was relatively easily understood, the Law Commissions put forward an interpretation which appears to be inconsistent with the views expressed in their earlier reports, and of course the views expressed in the case law. So far from clarifying the meaning of an ambiguous phrase, this paragraph in fact does, in many respects, the opposite. It introduces doubt as to the meaning of a phrase which is supposedly easy to understand. And then on top of that, it is not actually clear whether the Commissions are suggesting that a duty of honesty would involve any expansion to the existing law on directors' duties. Because after all, what they are talking about in this paragraph is not the content of directors' duties under the general law, but how best to codify the general law. The Court doesn't need to resolve what the Law Commission meant in this passage, because, as I say, with all due respect to the Commissions, its views on the meanings of the words good faith, as used in section 172, are simply not relevant. And as you know, the Company Law Steering Group did subsequently propose including an explicit duty to act honestly in the formulation of their duties. And that was rejected. I might just remind you of the reasons given for that rejection, which is at page 2058 of the hearing bundle. At paragraph 3.13, the first point to note in the reasons is that an explicit duty of honesty was very widely supported, but it was considered undesirable and unnecessary, and the concern of the steering group was the idea of an overriding and general duty to act honestly, which could give rise to a conflict with the director's other duties. And the example which they give is of a conflict between honesty, and the example which they give is telling. This is the point which my Lady Rose made this morning. Because the example they give is not a director acting dishonestly towards the company in which they hold office, but towards third parties in the service of the company's interests.
Yes.
Of course.
Yes.
I'm just finishing now, my Lord. And the only point I wish to make is that the concerns which led the group to reject an explicit duty of honesty are simply not engaged in the present case. We simply don't know whether the steering group would have regarded Mr. Costa's conduct as being in breach of the statutory duty under section 172. But that doesn't matter because it's not relevant. It takes me back to my overarching submission, which is that the meaning of the words used in the statute are not a matter for the steering group or indeed the Law Commission, but for this court, having regard to the general law which the provision replaced.
Yes, thank you, Mr. Rowett. Yes, Mr. Craig.
Just a few bullet points. I would start with the case law before the 2006 Act came into existence. My proposition in opening was that there was no case in which an objective test was applied. My learned friend referred to the National Funds Association case, which is, if you want a tab number, tab 81, page 4997. That has nothing to do with the present dispute. It was a case in which ultra vires payments had been made by a company, and the directors were attempting to raise a defence to the recovery of ultra vires payments on the grounds that they had acted in good faith. And in that context, the judge said, well, I'm not very interested in what you thought. These were ultra vires payments. The other two cases my learned friend referred to were item software, tab 68 if you want it, page 4416. That was a case involving an attempted diversion of a corporate opportunity, which was plainly a breach of fiduciary duty. And what Lady Justice Arden, as she then was, said, was that part of the duty to act bona fide in the best interests of the company is a duty to disclose your own misconduct. That can't help my learned friend in this case, because it begs the answer to the very question in issue, namely whether Mr. Costa has been guilty of any misconduct which he was required to disclose. It is also incidentally the case that in item software at paragraph 41, her ladyship describes the duty as being based on the duty of loyalty. That's paragraph 41, page 4428. A director cannot regard it as being a step taken in the interests of the company loyally if he knows that the decision he is taking is to divert corporate opportunity. And exactly the same point can be made in relation to the third case my learned friend mentioned, O'Neill de Falbe, where again he says that it espouses an objective test. That's O'Neill de Falbe is at 4697. The relevant passage is at page 4708 in the judgment of Lord Justice North. Again, that was a situation where the directors were just blatantly pocketing company money. And in that context, the judge said they could not consider that in good faith to be in the interests of the company. We submit that the reason for that is, again, because that was plainly a breach of the duty of loyalty because of the conflict of interest there. So we are, with respect, left in the position that no case law before the 2006 Act was passed espoused an objective test for this duty. None of the professional commentary espoused an objective duty. And one then turns to the Lawcom reports and the CLR reports, which are, in our submission, plainly, contrary to what has just been addressed to you, plainly relevant, both as containing a reliable summary of the law as it was, and as guidance as to what the Act means. On the first point, there is no dispute. On the second point, we were frankly surprised to hear that extra statutory material is inadmissible as an aid to interpretation. We had thought, since if no cases in Spath Home 25 years ago, it was apparent that that kind of extra statutory material is a relevant aid to interpretation. And on the particular facts of this case, it is avowedly an aid to interpretation because the explanatory notes at page 577, paragraph 300, say in terms that the intention of the Act is to give effect to the recommendations of the Law Commissions and the CLR. So to suggest that, therefore, the reports are inadmissible in interpreting the Act is, with the greatest respect, nonsensical. And the same point can be made in relation to the White Paper, which preceded the enactment. The White Paper is at page 2972, which makes exactly the same point about adopting the recommendations of the Law Commissions and the CLR at pages 2979 and 2982. The one point of substance as to the content of the reports is the suggestion my learned friends have made that what was being proposed was a duty of honesty to the world at large. And in our submission, that simply cannot have been the intention. What was being codified was the director's fiduciary duties owed to the company. It is, with respect, nonsensical to talk about a fiduciary duty owed to the company, to be honest, with regard to somebody else. And it is doubly nonsensical when one actually looks at the draft provision. I don't have time to go to it, but if you go to page 1593, you will see that the duty of honesty was stitched into what became Section 171, the duty to act consistently with the company's constitution and for proper purposes, and at that point it was suggested honestly. And what became Section 172 was expressly stated in that proposed draft to be subject to compliance with that duty of honesty. So it was absolutely the case that what was under consideration was an express statutory obligation to exercise powers in what a director considered to be the best interests of the company honestly. And that is the decision that was rejected. That was the proposal that was rejected. So all of the material leading up to the Act supports the position we've taken. The Act, for the reasons we have said, is clearly a statement of a purely subjective test, and I've pointed out, and there is no answer to the observation we made, that when the Act wants to impose an objective test, as it does in Section 174, as it does in 1157, it does so expressly. And the absence of any objective test in Section 172 could not be more striking. There is no answer to the question, there is no answer to the point we made that all the case law and all the professional commentary until the Court of Appeal judgment in this case, have taken exactly the same view. This Court of Appeal judgment is an outlier. It represents a wrong turn in relation to Section 172. And we do ask the Court to overturn it. Specifically in relation to the discretion that was exercised in this case, some submissions were made as to the basis upon which the Court of Appeal exercised its own discretion. In our submission, if you go back to paragraphs 131 to 133 of the Court of Appeal's judgment, it is, in our submission, absolutely clear that the Court of Appeal was saying that it felt entitled to exercise its own discretion because the first instance judge had proceeded on the basis that there had not been a breach of 172, and the Court of Appeal held that there had been a breach of 172. So if we satisfy you that the Court of Appeal was wrong in saying that there was a breach of 172, the basis upon which it exercised its discretion would fall away, and the judge's order would have to be reinstated. That is the only, and in our submission, inevitable consequence of that outcome. The learned friend has flirted with the suggestion that the judge at first instance failed to make the usual order for an unconditional buyout. But the Court of Appeal didn't deal with that point. They said they would defer consideration of that point until they had considered the arguments about breach of 172, and then the Court of Appeal doesn't revisit it. So if my learned friend had wanted to raise in front of you an argument that the trial judge erred in the exercise of his discretion, even if there had not been a breach of 172, they would have had to say so in their acknowledgement of their notice of objection and in their case. The rules are quite explicit on that, and they haven't done that. So it is not, with respect, open to my learned friend now to say, oh, well, the judge departed from the usual order, because that wasn't a point that was decided in the Court of Appeal, and it hasn't been expressly raised now, and we don't have the material in front of you to answer it, because the question of why the judge made the order he did turns very largely on, if nothing else, the pleaded way in which the case was put. And this is reflected in the judgment, But the pleaded way the case was put was that Saxon Wood was deprived of the opportunity of getting an exit. And so the judge said, well, if that's the complaint, if in fact there would never have been an exit at any price that anybody would have accepted, you haven't lost anything. You haven't proved your case. And that's why he made the conditional order he did. So with respect, there just isn't the material fairly for this court to decide whether or not the trial judge erred in the exercise of his discretion. In the last minute or two, could I just mention a few points on the facts with which my learned friend opened, just to recalibrate things a little bit. First point, my learned friend took you to paragraph 202 of the trial judgment, saying that the board was unaware of the terms of the Jeffreys engagement. If you look at paragraphs 49 and 50 of the trial judgment, you will see that the judge decided that a draft of the engagement terms was sent to the board. Mr. Loy tried getting those terms changed, and Mr. Costa refused. Second point on the facts, my client made clear that he did not think the company could be profitably marketed during 2019, and that could not be clearer than it is in paragraphs 55 to 56 of the trial judgment. Third point, there are repeated findings that what Mr. Loy was complaining about was that he knew perfectly well that my client was not working towards concluding an exit during 2019, and we would rely in particular in the trial judgment on paragraphs 43, 46, 50, and 200. The board was given a presentation by Jeffreys, paragraph 73 of the trial judgment, and the slide that shows what they explained is at page 377, and it is clear they were not doing nothing, but they were keeping clients warm while a new CEO got going and numbers improved. Finally, just to again recalibrate things slightly, some questions were put suggesting that the shareholders' agreement represented some kind of unanimity of a desire to get out, whatever the price, so to speak. Again, that just isn't what the facts are. In fact, in the statement of facts and issues, there is a chronology. In the chronology for the 26th of October 2018, you will see that Mr. Loy wanted to impose a $150 million limit as the minimum price acceptable. And on the 24th of January 2020, you will see that Mr. Aspinall said he wasn't interested in an offer at 125 million, but he would be interested in something at 145 million. And you will also have seen from the trial judgment that 4 of the directors gave evidence for my client. And they, I think, according to paragraph 102 of the trial judgment, represented about 78% of the shareholdings in the company, and they were content to leave matters to my client. So it is the Court of Appeal has, with the greatest respect, taken an unduly crude and uninformed decision to interfere with the exercise of the trial judge's discretion without taking on board the true nuances of the facts of the case. sorry, it may not be that those directors themselves represented the 78%, but the 78% were content to leave matters to my client. That's paragraph 102 of the trial judgment. Unless there are any other points, those are our submissions in reply.
No, thank you very much, Mr. Secretary. The Court's grateful to Council for their submissions, both oral and in writing. We're also grateful to the teams of lawyers who have assisted in the preparation of the written cases. You've given us a lot to think about. We will reserve our judgment. This hearing is now adjourned.